The case has been stuck up in the road because of blocking of e-challan. I filed a case. My lord has granted leave, my lord. So Lordship kindly fix to be mentioned tomorrow because my lord has passed this order.
All matter be fixed tomorrow. All matter.
My lord,
All list, all fixed tomorrow.
my lord,
And I will sit till tomorrow at 8:30 p.m. till the list is completed. And if any of the advocate will absent at the time the matter is called, I will dismiss with cost of rupees 2 lakhs.
my lord,
We'll fix list, take all the matters and list tomorrow.
my lord, my humble submission. My lord, just 1 minute. Submission.
I am not wasting the time. Give all the
Only 1 minute. My lord, it was your honor was pleased to list the matter today, even after
What I
3.
am telling, whatever you give, all the may be listed tomorrow, and but with the condition, if in call either 8:30 p.m. or 9 p.m. If it is not called, not appear, 2 lakh rupees cost.
My lord, listen, my one submission. My lord,
if they are nobody interested to put this.
my lord, listen, my one submission. My lord, if the matter is not today heard in the supplementary list, my entire matter will be infractuous matter.
No, I am giving the matter. I am giving the
What can be done? This type of the officer has been provided to me. What can be done? What can be done? This is the third officer. I have requested third officer has been given, but I am not getting the support. In the open court, I am telling this.
My lord, you are pleased to pass the order to
Every
take
day,
the matter.
Advocate telling I have mentioned thrice or twice, but matter is not listed. What can be done? The court, the judge cannot go to the mandamus section and bring the file.
My lord, your honor was pleased to fix the matter even after 3 times of repetition.
What can be done?
So otherwise, my writ will be infractuous. I will be irreversible. Today is the last day. If it is not taken today in the supplementary list, specially.
Supplementary, I will not. If today, that's I'm telling you, whatever if it is time permit, it will be taken tomorrow.
That was I have already earlier given. That was fixed for today, but not listed. Again, I am submitting.
Person cannot today already 110 matters in the urgent motion.
Okay, my lord. Okay, my lord, take it tomorrow at any point of time. I would like because
let it be given. It will be taken tomorrow.
Tomorrow at any point of time. Please take this. Please take this. Tomorrow at any point of time. Otherwise, no, entire read will be infractuous. Then I have to compel to withdraw the read.
Leave may be granted. Leave may be granted to move the matter tomorrow.
Come after vacation.
Yes, some urgency. Tender matter.
What can be done? Why you have come on the 13th hour?
No, my lord, on 18th they have rejected the technical bit. Earlier, 21st they accepted. On 5th December, rejected. Then my lord accepted, then rejected.
Come on second. I will take.
May I leave, my lord? May I mention, my lord? The matter is Chinese.
Not understanding. You are not understanding English.
No, it has been listed, but at the bottom.
What can be done?
Lordship was pleased to hear the matter.
So tell me in which serial number your matter is to be fixed. Give the
137.
Go to the Chief Justice. Tell this serial number. Direct the court number 25 to fix this matter in this serial number. I will fix.
Madam, may I mention?
My matter will be.
May I please to mention one?
Chinese New Year will come. That is a school, my lord. You not to remember.
If anyone wanted the matter to be listed, give the list to my court officer. It will be listed tomorrow. That's all. Nothing else.
This is
nothing else.
Madam, may I please to mention on criminal matter, my lord? The criminal matter that should be a contested application as because that was dismissed and subsequently that was restored. So kindly allow me to maybe list it in a contested application.
What is the urgency, sir?
Urgency is that the matter is 2012. 2012.
Which year we are now?
And subsequently,
which year we are now? 2012 matter. Which year we now?
That was recently. That was restored.
So what do you want now?
Now that may be listed as a contested application.
Okay, it will come after vacation. It will be.
Malas, may I be permitted to mention, Malas, this is.
The ancient court is expired today, my lord.
You mentioned at the time of rising of the court, you mentioned.
This is for correction of your lordship's order, my lord.
Move an urgent motion, my lord. My lord,
No urgent motion will be allowed.
tomorrow, my lord, there is an urgency, my lord.
Nothing.
My lord,
That order be passed, nothing. Otherwise, we are helpless.
So that's I'm telling you, give whatever it is, will listed tomorrow. Nothing. Leave cannot be granted. You are not filing in the last hours. You're coming for leave to file the writ application. I will not allow that.
Then, my lord, allow it to move in the vacation bench. Otherwise,
Go and move.
my lord,
Lordship has released this matter, but only the CAN application has been released. The WPA has not been released. But that my lord, Justice Mitra told me that
Either
the CAN application along with the WPA. The CAN application has been released for your lordship.
the canvas there.
Yes, CAN application has been released. My lord, Justice Mitra told me yesterday that you have to release the WPA also
Correct.
from that. For that reason, I should take this.
इसको to be mentioned में रखो.
my lord, leave be granted, my lord, to move in the vacation bench, my lord. That leave be.
Leave is granted to move in the vacation bench.
my lord,
Leave is granted to live in the vacation bench.
But unusually compelling circumstances.
No new, I will not allow. I am telling no, I will not allow any new leave.
Seeking for any leave on that score. All that I'm seeking for, my lord, I cannot take out this application unless the leave is granted. Because, my lord, I need to file this application with the first title. Because I am not non-party to the writ.
Come after vacation. I
My
will.
lord,
my lord,
filed, my lord, I am not seeking for any listing before the vacation, my lord. All that I'm
Why you are filing this sort?
because, my lord, there is an direction which has been passed on me. I have complied with that particular order, my lord, pertaining to filing of some audit reports. Now, my lord, all that I'm seeking for is this report is required to be filed. I am a non-party to the proceedings. All I need to do, my lord, is have this application filed. With the leave that I'm a non-party, my lord, let this application be filed with a short cost.
Leave granted.
my
Lord, may I have your lordship?
Short cost rate. Great.
My lord, may I have your lordship?
To file with
Sorry,
the
sorry.
short cost rate. Yes.
May I have your lordship's kind leave, my lord? I am seeking for an unusual prayer, my lord, a leave to file a writ petition with short service so that it can be taken up tomorrow. I'm just trying to save a company. My lord, the NCLT proceeding is made returnable. Final hearing on the 5th of January on the reopening day of the NCLT. Well, 4 additional directors have been appointed fraudulently and they have been uploaded before the MCA portal, which is the Register of Company. I have already lodged my objection before the Register of Company. I'm the managing director of the company, saying that this has been fraudulently done. Mark it with objection. What is happening is that they have now, I was the managing director, 4 additional director. Now they will take charge and the company will go into insolvency. So that unless, well, if before 5th I don't get any order, my lord, the entire process will become.
Okay, second it will be listed.
No, my lord, order I'm
Leave is granted.
yes, well, kindly to short cost title. In the event it is possible, I will serve them. I will serve the RD and the.
Sir, if I am allowing, let the matter appear on second as a, under the adjourned motion.
Very good. Very good.
Leave is
Very
granted.
good. Kindly give us the leave, my lord. We will file with short cost title. I mean, with short service, I will serve and then if possible.
Leave is granted
Great.
to file the writ application with short service. List the matter on second as urgent motion.
Great.
My lord, pursuant to order of the court, my lord, my junior had given the court fees, 50,000 rupees to government portal. So transaction failed. The 50,000 rupees has not come back. Now, my lord, the Canada Bank day before yesterday has, my lord, informed my the petitioner before lordship that the chargeback has rejected. My lord, it was given pursuant to orders of the court. It was given in the government portal. The transaction failed. It is in the GRIPS portal, my lord. But, my lord, when the bank is, my lord, nationalized bank, when he had approached the nationalized bank, he's saying that the chargeback is rejected, my lord. Kindly, my lord.
What is the urgency?
Urgency is, my lord, junior member here paid 50,000 rupees from his bank. It is not coming back.
After vacation.
Kindly,
Come after vacation.
he grants me leave to, my lord, move as short service, my lord, with the short service after vacation.
After vacation, within a week, you can serve the notice and come on. What is the service, sir?
my lord, this is for correction of your lordship's order, my lord.
To be mentioned for correction.
Very public.
To be mentioned for correction tomorrow.
Very public to mention.
the tender matter. I have been granted work order on 18th of December, my lord, and now the authority is forcing me to take his main, my lord, or else they will authority, my lord, the authority who have issued the tender, my lord, they are forcing me to take his main, my lord, and they have issued a letter, my lord, or else they will cancel the work order, my lord.
What the authority done?
Well, they are recommending two names to be taken under my head, my lord. And I will give them a work. But that is illegal, my lord, or else they will cancel the work order, my lord. Work order has been issued on 18th of December, my lord. My lord, kindly take it tomorrow. Or
Take my list and
my lord,
list here.
My lord.
You take my list and point out which serial number your matter is to be listed.
My lord,
I will list your
take
matter.
leave to file.
You take this and advise this court which serial number your matter can be listed as urgent motion.
My lord,
Take
the vacation mail, my lord. I am praying to leave to file in the vacation mail, my lord.
leave is granted to file in the vacation.
Tender has been cancelled, my lord, even when.
Leave is granted to file in the vacation bench. Leave is granted to file in the vacation bench. Yes.
And these matters that get in the lordship to 120 the recruiting body has fixed a cut-off date lordship by because the candidature of the candidate can fight of being successful.
In spite of successful in the
Issuance of EWS certificate.
The EWS certificate is the authority. How the court will so what the court will do?
We have challenged that rejected order. The reason order we have.
When you are challenged, when the EWS certificate was rejected.
It was rejected in December.
When?
11th December.
When you filed the writ application.
By the your lordship.
Okay. Which serial number it is listed? So which serial number you want to be listed the matter? Which serial number you wanted to list the matter? 100 matter is urgent motion. Correct. That also urgent. This court has fixed. You tell me which serial number you matter. 112 want. I will take the 112 or 113. Not before that, because all the urgent matters. That's why I'm telling all the members of the bar. Tell me which serial number your matter is to be fitted. Because all the matter is the urgent motion as per your request, not as per the court, as per your request of the bar. And you persons are not allowing me to go beyond 20 matters. So half an hour is completed for the mentioning. So, उसको रखो कल तुम्हारे.
Maybe permit to mention.
This is the.
Joseph,
आप किसके ऑफिसर है? मैं यहाँ बोलता हूँ, आप में बात क्यों करते हो? उनका लो कल अर्जन मोशन में लो.
Item number 125 of my lord today's dismissal. But I understand the bench is not. What I beseech my lord, that this can be kept on the first 10 matters on the 5th, my lord. If it's possible, my lord. The first 10 matters, my lord.
This the matter as urgent motion under serial number 1 in between 1 to 10 on 5th of January.
Lord,
Urgent motion mein. It is urgent motion. That's I'm telling where your matter can be. The other advocates will. Okay, you wait. See today how far the court will go. Yes.
With your lordship's kind leave, my lord. I have realized the pulse of the honorable court.
me too. I should say me
Our
too.
departure, my lord, for tomorrow only, my lord. Insofar as, my lord, the urgent matters
Yes.
which are listed tomorrow are concerned, my lord, grants us, my lord, a special mentioning opportunity tomorrow morning, so that whoever has urgent matter, they can mention it and get the matter heard out tomorrow itself, my lord.
Yes, from the list. That could
From
be done.
the listed matters, my lord.
So whoever has urgency.
That's why I'm taking that. That's why I'm telling. Which matter is already listed, I will take.
I was here to mention item 128, but I'll try my luck tomorrow, my lord.
Correct. No
I'm
problem.
mentioning upon notice, but tomorrow.
Let me see how far the court.
My lord grants us only that special, that is a Christmas bonanza,
I
my
will
lord.
take
Lord, apropos to item 134, I would only say, Lord, that the respondent cell has blocked their website. I cannot participate in the tender.
In the last 3 occasions, they lost before this court, before the division bench. They could not succeed in a process to ban me. Now, in a surreptitious way, I can't go into their website and file the tender. 18th was the last, 19th was the last date. We filed it with a leave, but the financial bill is yet to open. If it is open, then it will become infructuous. There's nothing that any one of us will be able to do, because still the technical evaluation is going on. I want to only participate. That is the thing I want, not. If my lord diary permit tomorrow, kindly give me a chance tomorrow. Let it appear at the top.
127, 128 it will be. I don't know what.
No, 134, 134, because this is genuinely urgent. This is genuinely urgent. If my lord feels that my lord can spare 5 minutes time tomorrow, let it come at the top.
Okay, I will take note of it.
I'll come back before rising and will not renew my prayer. Kindly grant me that liberty.
But may I seek your lordship's indulgence, that leave was granted in 2 matters for today. And as item number 124 and 135. Would it be possible to take up today? Extremely sorry, Lord.
What can be done? I have to accommodate all the advocates.
I understand, man.
Correct. I cannot say no, your matter will not be taken, your matter will be taken.
That's the option.
Please wait till today how far this court will go. Then tomorrow we'll see how the matter can be disposed of, which is considered as urgent motion. That's why I'm not taking the new urgent motion in the list. So that what are the matters of the urgent motion, I will try my level best to dispose of all this matter. Okay.
My lord, I may appear.
Had it been otherwise, Lordship, I wouldn't have approached.
At least those matters in which.
Okay, please wait till tomorrow. We'll see to that what is the situation of the court list.
Lordship, citing my urgency on
Madam,
previous two occasions,
in person
the court officers to list this matter on 22nd, Lordship, or else I wouldn't have come, my lord. The only difficulty is I had been operating business from the premises for the last 35 years, which is within the premises of the Calcutta Port Trust. Now, behind my back, in against some ex-party, we do not know, order is passed, an eviction notice is given to me. My entire factory is locked. I had filed this petition on 4th of December, my lord. Anytime, Lordship, I cannot stand in the way of the court, Lordship. I know how burdened the court is with the list. Lordship, anytime, Lordship, I can, if this side of the vacation or else on
which number your matter is not listed.
Yes, it is already running in the list as 661.
660.
I filed it on.
ठीक है, उसको कल को उसमें urgent motion में करो, देखो कब होता.
Yes. May I be permitted to mention? May I be permitted to mention? I'm not on to urgency or anything. Only inclusion, Lordship, in the month of Jan.
New motion.
My lord, my prayer is also inclusion, my lord. I mean,
month of January.
inclusion.
New month of January.
May I be permitted to mention? This matter is heard on 15th of December and thereafter 16th of December under heading urgent motion, my lord. But due to paucity of time, the matter could not be taken up. Today, the matter is serial number 109. If possible, my
109. Please wait till how far this court will go today, then we'll see.
My lord,
mention on matter. Lord, the petitioners therefore issuance of BW certificate has been rejected, my lord, by the council ATL on the ground that is subcast has been subsequently included in the state OBC list, my lord. Now, my lord, the recruiting body SSC, they have maintained a cut-off date within which I have to procure my certificate. But a recent order was passed on 11th of December. We have challenged that, my lord. So, Lord, kindly takes it in tomorrow, my lord.
Which number?
But it's not listed, my lord.
So, what can be done? No.
So, it's filed on 18th, my lord.
What can be done? 18th you have filed. Yes.
My lord, considers, my lord.
My lord, I am praying for upgradation. My lord, on the last
For moving the vacation.
Yes, leave is granted. Where is the petition?
But it isn't filed.
Leave is granted. So leave is granted to mention before the vacation bench.
My lord, I am praying for upgradation. My lord, my lord, I am praying for upgradation. My lord,
upgradation come in the month of January.
may I permit to
Not today.
May I permit to mention to move this matter before the vacation bench, my lord? My lord, may I
Leave is granted to file before the mention before the
May I be permitted to mention a matter? My lord, the matter is related to the arbitrary disconnection of the electric supply from the petitioner's house. Now, the petitioners are in very precarious condition as to
when it was disconnected.
My lord, it was disconnected in the month of August,
Hmm.
and they till date they are having no electricity. And
4
order
months,
of-
what you have done within 4
My
months?
lord, we have filed the writ, we have filed the writ petition. However, it will not be taken up.
Ah.
But the problem right now is the daughter of the petitioner is having her college examinations, which are
And
extremely important.
when the college examination starts?
The college examination will commence in January. And
January which date?
January approximately
Okay, you wait for the come on second.
My lord, this is
So
extreme.
second
She
में
won't be.
you second में urgent motion.
My lord, it is currently running in the call list as item number 630. Kindly take up because it won't be 630.
That's why urgent motion on 2nd January it will
My
come.
lord, she won't be able to study in the
You
whole
mention if it
vacation.
is not, you mention on 2nd January, I will see to that because today it is not possible.
Taken up tomorrow, my lord. Please, she won't be able to study the whole vacation period. She's in extremely depressed condition.
काम करो उसका मैटर को कल उसको करो एज स्पेशली फिक्स करके टॉप में रखो स्पेशली फिक्स करके टॉप में रखो if I find it is you bring the this date sheet of the college examination. If I find it is not correct, then you have to be cost will be imposed. You have submitted, I am taking only because of the examination of the student and bring the date sheet of this schedule of the examination.
My lord, the CU is the authority to establish the
अरे
date
तुमको
sheet.
जो मिलेगा वो लेके आना.
Because I am fixing especially fixed on your submission. If I find your submission is not correct, then you have to put the cost.
This is regarding a Bangladesh infiltrator lordship who has managed to obtain lordship, procure, take records lordship, documents lordship like passport and all that lordship, and he's also involved in a criminal case lordship. Now lordship, the case is criminal case is pending lordship, and also managed to record his name in the draft SIR lordship. So may I be allowed to move the matter to accept?
Move before the leave is granted to move before the vacation bench.
May I will also kindly to mention urgent matter. This appearing is item number 110 under the motion, under the update urgent motions, Lordship. I know my lord is still working with all the matters, but for only one thing, if you can be proper update tomorrow, my lord, because the reason is
See tomorrow list how far the today how many matters would be disposed of. Then it will be taken.
that is also can you give us the leave to mention tomorrow once again.
Leave notice. See that list tomorrow.
Your
Then
Lordship,
yes.
131, this was pursuant to the leave granted by this honorable court. I'll come back tomorrow, Your Lordship, if at all it is not taken up. Your Lordship, the urgency is that on 19th of December, eviction demarcation notice was issued. I already have a lease granted by Zilla Parishad, and SDO under the Highway Act is issued me a notice cancelling the lease granted by one authority. One authority cannot declare the lease granted by another authority as void because it's not a competent court of law. So I'm urgency is that I may be evicted.
Okay, you can wait tomorrow.
Your Lordship,
for this
Your
court
Lordship,
today.
Your Lordship.
I am praying for child without getting NOC from the previous
NOC from
previous advocate.
Writ petition for previous advocate. How it can?
This is the original side.
Original side. How this court can grant the leave? This court is not having interpretation of original side.
My lord, the matter is listed item number 6. Today, I listed item number 6 to 8, and the urgency is the petitioner and her minor soul is evicted.
Huh?
The petitioner and her minor soul is evicted from her matrimonial house. So kindly take it before the
Come after vacation. Come after. Not tomorrow. It is not possible.
Sir, before the vacation bench.
Vacation bench. Okay, leave is granted to move before the vacation bench.
My lord, the trials other detained in a hospital, my lord, but without any treatment, my lord. Metastatic cancer, my lord, without any treatment, my lord, he has been detained on the ground of non-payment of bill. I mean, he has been detained as a hostage. That you first pay the bill, then you release the patient. But my lord, the hospital doesn't have any infrastructure of treating carcinoma, my lord. And now, my lord, every day the situation is.
So what you prayed before this court? What is your prayer here?
My lord, my prayer is, my lord, that he may be released to a government hospital.
So if you have got the treatment from the hospital, you have not paid the bill amount, what the court will do?
Lord, I undertake to pay the bill, my lord.
When?
But at this point of time, my lord, because of the payment of bill, my lord, the treatment will be stopped, my lord. That is
So
the.
who is not giving the treatment? Hospital is not giving.
The hospital is not giving the treatment, my
So
lord.
because you are not paying the amount, which hospital?
My lord, Urban Healthcare,
Huh?
Urban Healthcare LLP.
Where it is?
My lord, it is in Garia. It's in Garia. My lord.
So you are not having the money by your
No, my
account?
lord, I undertake to pay the money.
Ah.
For whatever agreement, whatever undertaking, your lordship, please, I am ready to give that undertaking. In fact, my client had proposed to give them a post-dated check also. But my lord, they are not agreeing to that. Now, my lord, because the payment.
What is the due amount pending before the?
3 lakhs due amount is pending, and my lord, 90,000 I can.
So how the court can decide here?
I am not telling the court to decide, my lord. I am not on disputing on facts also. I am admitting the 3 lakh amount. I am saying that I will pay you. But the thing is that kindly release my patient. Kindly doesn't take.
So if they release the patient, you will go and who?
I will be whatever the whatever.
So how the hospital authority will go behind you?
My lord, whatever requirements are there, whatever security needs to put to the hospital, we will be putting that security.
What security are putting?
We will putting posted check and all, my lord. But my lord, metastatic cancer, my lord, the patient is not being treated, my lord. My lord, kindly considers, my lord.
तो कल रखो, कल इसको रखो, दूसरे के स्पेशली फिक्स करना ना, इसको भी करो.
My lord, item number 663 of your lordship's list. Item number 663 of your lordship's list, my lord. I will not pray for an upgradation, my lord, because as my lord is already overburdened. My lord, I am praying for leave to move before the vacation bench.
Leave is granted to mention before the vacation bench. Yes.
Your lordship's kind leave. The last meeting matter of 2025, my lord. Meeting is on 28th, my lord. This is the last meeting matter of 2025, my lord. 28th is the meeting.
When the meeting?
28th, my lord. Yeah. No, I understand, my lord, after yesterday, possibly, my lord, from 2026, these matters, my lord, these will get eliminated now. Once the guidelines are framed, that is what I hope, my lord. I am fervently waiting for the 22nd of January when the matter is made returnable. This is otherwise very tiring.
So the leave is granted to affirm the affidavit this tomorrow. At 11 खाली है तो देखो.
Great.
खाली है. ठीक है, देखो एक टाइम में रख देना.
Extremely.
Time. Yes. Call the list. Sorry, dismissed. Go with the coffee, with a cup of coffee with the Mr. Bhattacharya.
Yes. We are always in that topic. Chalo, Judge Sahib bole order file kole kita mention.
Yes, next.
I appeal for the petition.
Here I allowed the petitioner to implead the municipal corporation as well as the fisheries department as respondents and issue notice, and they are directed to file the affidavit in opposition regarding entry model will be decided after exchange of affidavit.
Obliged.
Next.
My lord, item number 3, I am for the petitioner led by Mr. Divin, who is on virtual mode, my lord.
This is an extension of interim order, my lord. Interim order will expire, my lord, in the end of December. Can you come to, my lord, the order dated, my lord?
You are for the respondent.
I am for the respondent, but clinical establishment authorities are the main answer.
Which for the clinical?
My lord,
You are appearing for?
for the clinical establishment authority commission. The respondent number 4, perhaps. Yes.
So I am extending the interim order. Have you filed the affidavit? There is a direction for affidavit.
No direction was there.
There was no direction.
So you let the affidavit be filed,
My lord,
or will
humble submission, my lord, where the regulatory authority. So what we have in our is already in the petition, my lord. So, my lord, we do not have any other documents to produce before.
So without affidavit, it can be heard.
My lord.
So you are only
And one more humble
the matter is listed as to be mentioned for extension of the interim order. Full list of counsel for the clinical. What is the
Establishment.
counsel appearing for the? You are appearing for whom?
Respondent number 4.
Respondent number
4, the added respondent.
The clinical test.
2, 3. Respondent number 4. Submit that. Submit that he will not use any affidavit accordingly. Affidavit full stop. Accordingly, let the matter appear on 4th of February 2026 under the heading adjourn motion. Interim order is extended till 6th of February 2026 or until further order, whichever.
Oblige, my lord.
Oblige, my lord. Grateful, my lord.
Point number 3 is the patient, my lord. So his presence is also necessary for this.
Let me.
My lord, we have served.
We have already
Time
served.
of filing the writ petition, we have served.
If required, then I will pass on. Yes, next.
Oblige, my lord.
I am appearing for the state respondent lordship. On the last occasion, my lord was directed to file the opposition lordship. It may be kept with the record and
Extension of interim order,
and
lordship.
extend the interim order. I am not opposing, but for the limited period lordship.
You are filing affidavit.
Lordship, I am also filing reply.
Reply. What is the matter?
Lordship, it's a tender matter, lordship.
Matter 2022 lordship, several occasions it was extended, kindly fixing up the
Respondents have filed affidavit in opposition after serving the copy to the learned counsel for the petitioner. Petitioner has filed affidavit in reply. Let the same be kept with the record. The counsel for the petitioner prays for extension of interim order. Interim order is extended. February में कोई date है देखो स्पेशली फिक्स में तो डायरी अपने पास रखिए ना. February में कौन सा डेट है? Let the matter appear on ये ढूंढने की क्या है? हाँ? 5th February at 2 p.m. as a specially fixed matter. Interim order is extended till 6th of February 2025 or 2026 or until further.
Grateful lordship.
Whichever is
इसको दीजिए.
Yes, next. Call, speed.
My lord, I beg to appear on behalf of the petitioner. With an extension of
जल्दी करें, आप रेडी करके रखिए. देरी टाइम वेस्ट मत कीजिए.
This is my exception to the
report. Yes.
This is my exception to the report. The matter.
What is the can one?
This is the extension of interim order.
Who is appearing?
Lordship,
Yes.
subject to a lot.
Yes.
Yes. बोलो ना.
Subject to a lordship kind consideration. Your lordship, writ petition, it relates to the dues outstanding by the bank. The bank has filed Section 19 application before the Debt Recovery Tribunal. Section 19 application is at the stage of admission. The disputed question of facts has been raised by the petitioner in the writ court that the loan was sanctioned not in accordance with law. Bank has not adopted norms. So all these facts requires adjudication on facts. So let's since Section 19 application has been filed, he has also been served with the notice of that. He also appeared, but since there is an order of stay.
So what I am telling, I am fixing in the 6th of February.
Yes, Your Lordship.
As a specific.
I leave it to your lordship.
Specific matter. So the matter can be
I
discussed.
leave it to your lordship. I leave it to your lordship.
The petitioner has filed an application being Can 1 of 2025 for praying for extension of interim order. Counsel for the respondent raised objection and submit that the writ petition is not maintainable as the bank has already initiated a proceeding before the
DRT.
Death recovery time. Consider the submission made by the counsel for the parties. For the interest of just this court finds that the petitioner already enjoying the interim order. Accordingly, the interim order is extended till 6th of February 2026. List the matter on 6th of February 2026 as a specially fixed matter at 2 p.m.
Oblige. With your lordship.
But petitioner will not proceed with the matter.
Yes.
Will not proceed with the matter.
Not proceed. We have a written instruction, no? Counsel for the petitioner submit that he has instruction that the petitioner is not interested to proceed with the matter and pray for withdrawal of the instant date application. Consider the submission made by the counsel for the petitioner. WPA 20426 of 2025 is dismissed as withdrawn. Interim order if any stand vacated. Next.
Well, this is appearing at my.
Lord, I appear for the respondent number 4. I find in the list it is marked as modification. There is no modification application filed. Lord,
May I
on a
finish?
farmer
I don't
prayer,
understand why. What is this kind of?
there is no modification
Please
application.
come at
I'm
my
pointing
instance,
out.
Let yes.
Malad, this was mentioned, Malad, and it was taken up for the purpose of extension of interim order.
Lord, no notice served. No notice served.
Arey baap re baap.
No,
But
no,
I'll
sir.
hand over only 3 orders to your lordship, and I'll just say whatever I have to say. My lord will kindly
No,
consider.
that's all right, bro. But not only one thing, before my learned senior friend starts, there are other respondents. I don't know whether they are on notice or not.
Served, I showed the other page. I'm sorry.
When
yes,
the
Your Honor,
mentioning was done, no notice
Sorry.
was served on me. Today also I have inquired from my advocate on record, no notice has been served on us. I was there.
I am
They're
for
all
the
like,
state in item number
on the mentioning day, for some other matter, I could follow and come. So no notice has been served. Secondly, a modification is sought to be made without an application. We don't know what is the modification.
Yes.
So let them file an application if they want modification.
Yes.
This matter had appeared for the purpose of extension of interim order. Malad, kindly sees the first order, that's 14th of October. Malad, I've given 3 orders together. Down?
14th October. Yes.
Malad, that is 14th of October.
Correct.
When this matter was moved, Malad, there was a challenge to an order passed by the walk-off board. Now, Malad, I will not take your lordship the entirety. Malad, kindly takes page 2. Your lordship will kindly see the para number 10. Pending hearing, the impugned order be stayed till 18 December or further order, whichever is earlier. And your lordship, my lord, the maintainability was kept open. So this was on 14th of October. My learned friends went up in appeal. Now, my lord, your lordship will kindly see the appellate order. This is of 10th November 2025. My lord, I think I've handed over.
This was said on the last day, an order has been passed. Mr. Rai is on. I don't understand. Then he's asking for a review. Your lordship has considered all this and passed the order.
May I?
Yes.
My lord, kindly sees, my lord, then kindly takes page 3
Yes.
of this order, my lord.
Correct. Clarify the stay operation of such granted by the land.
Yes.
Shall not
So, my lord, no.
stand in the way
But only one paragraph, my lord. 5 kindly sees 5, my lord. Read petition pending. We are not inclined to go into the merits of the case. So it did not go into the merits. It only clarified. My lord, this is para 6,
Yes.
which clarifies the state to the extent the criminal part has stayed. And there is another direction, my lord, which is at para 8, which says till the learned single judge decides the writ petition, let status quo as of today. So, my lord, the single bench's order was kept with that, the clarification made and the further order passed. My lord, this was passed at their instance, so I don't have a problem with that. Now, my lord, your lordship appreciates 14th of October order, my lord, was regarded to be extended. When this was mentioned before your lordship, my lord, kindly now takes your lordship's order, my lord. Well, this is what I'm asking for. I will leave it to your lordship. And then if your lordship directs me, I'll take out an application. Well, kindly sees your lordship while considering the extension. But the extension has not been mentioned. Your lordship only mentioned in para 6. If your lordship kindly sees.
Yes.
Honorable division bench already passed an order of status quo.
Till the disposal of the.
Well, that is the part which the status quo has been passed. But the part which this walk-off order was stayed and clarified, that has not been extended. That is what I'm on.
Not single judge decides the writ petition, let the status quo as of today with regard to the possession of property.
Possession, yes, one. That's only possession.
Correct.
But the first part, if your lordship kindly takes para 5. Para 5 of the division bench order says we are not going to the merits.
Yes.
It also says now 6. Malad kindly sees before addressing in so far as the direction of the walk-off board to the CEO. So Malad, that is included in the order.
We only clarify the stay of the
Yes.
operations that granted by the Salon Singer shall not stand in the way to a walk-off board or state initiating the criminal action.
Therefore, the stay was extended. It only clarified. That part has not stood extended by your lordship's order. The stay part. Malad, kindly may I explain, Malad? There is a walk-off board order. That was stayed by the single bench. Division bench did not touch it. It only clarified. And division bench out of its own passed a further order. By your lordship's order, the further order has been recognized. But the single bench's order, which the division bench has not set aside, that was limited. I wanted extension of that part, Malad. That has not gone down in the lordship's order. That is what I'm on, Malad.
How could it go?
So, see, already there is an order passed by this court staying the order of the walk-up.
That's limited, Malad. That is the problem. That's why I've come up with your lordship, Malad. That is limited.
Till 18th of December.
That is why, Malad, I had come up with your lordship.
Yes.
Lord, may I say this? Firstly, on 15th of December, my lord has already passed an order. Now, if he wants a modification, he should come up with an application. By oral prayer, with greatest of respect to him, modification cannot be granted. This is number 1. Number 2, my lord kindly takes the first order passed by Justice Dattopal on 14th of October. Kindly come. Lord, I don't know why distorted facts are being placed in this way. Kindly see what was the issue. Kindly come to paragraph 4 of the order 14th October. Learned Counsel has placed inner page number 23 of the impugned order wherein it appears that certain directions to the Motawali have been given to carry out certain acts of the petitioner therein. In the last paragraph, it is directed that start criminal proceeding against the petitioner, apprehending the same, the writ petition has been preferred. So his apprehension was that a criminal proceeding would be started. Justice Dattopal, after recording, kindly read para number 5. The learned senior counsel appearing for respondent of 5 submits that the order challenge has already been given effect. Possession has been taken. Then on that conspectus, Justice Dattopal directed that the impugned order shall be stayed. Initiation of the criminal proceeding. We preferred an appeal. Kindly come to the appellate court order.
Yes.
Lord, kindly take paragraph 2 of the order. Mr. Rai was represented.
Yes.
It appears the respondent who wanted to hearing had some property dealing with Mutawali Waqf, which was vetted by the board. Certain disputes having reason to the such arrangement, respondent approached the court. Before the learned single judge, point was taken on behalf of the present appellant as well as the respondent of 5 in the writ petition. The writ petition is not maintainable since the order challenged in the writ petition are appellable under Waqf Act. Then kindly take note paragraph 5. The writ petition is pending before the learned single judge. We are not inclined to go into the merit of the case. Learned single judge is yet to decide. So the court did not go into the merit of the issue. Then we request the learned single judge to decide the issue of maintainable writ petition insofar as the same is preliminary issue. Insofar as the direction of the Waqf board to the CEO of the estate to initiate criminal proceeding, we clarify. So the portion of stay was clarified that the stay of operation of such order granted by the learned single judge shall not stand in the way of the Waqf board in initiating criminal proceeding. So Mr. Rai asking your lordships to extend the stay which has been clarified by the division bench. Please don't interrupt. Please don't interrupt. Please don't interrupt. I'm requesting you. So the order has merged with the division bench order. He should go there and pray for modification if he wants. Then kindly see, we have entered then para 7. We have not entered into the merit of the case. All points are left open to be decided by the single judge in accordance with law. Then para 8 comes. So the stay portion is modified. Further interim or protection is that status quo should be maintained. Now, your lordship on 15th of December, after hearing Mr. Rai, passed an order. Kindly see 15th of December order.
Yes.
Today, he is again coming and saying that you modify that order. These submissions are made, your lordship has considered this.
Yes.
Let him go to the division bench. If he is aggrieved with that or higher up, Lord, a interim stay on the initiation of FIR was granted. Division bench clarified that that order shall not stay in the way if we are entitled in law to file an FIR and further status quo.
Yes, Mr. Ray.
Yes.
Well, now may I say this, Malad?
Kindly come to the paragraph 4 of the original order of 14th October.
Yes, Malad.
Correct. 14th October, you have given the apprehension before this court and this court has stayed the order. Kindly read the paragraph 4 and
Yes,
the council has placed
I've
the
seen that.
then paragraph 10 interim order was passed. Now kindly come to the division bench order
I've seen
paragraph
that,
6.
Malad.
Yes.
So paragraph 6 it I already clarified. We
Yes.
only clarify that history of the operation of such
Yes.
order granted by the single judge shall not stand in any way to the Waqf board for stamp. So I am again recording this only. If you
Malad,
want that, if you want the
May I say this, Malad? It is
notification.
obvious, Malad, when I'm obviously targeted and said to keep quiet, Malad.
Not
Should have-
targeted. I'm
yes.
sorry, not targeted.
No, Malad, I've taken major offense to this, Malad. Then you should have the correct intention of showing the order then.
Well, I have
Because
shown it.
no, you have not.
Then you show it.
The
You show the
Waqf
correct
order-
intention.
Mr. Ray, say Mr. Ray, court has to see the
Malad, your lordship will read the order
Correct.
in terms of the order. Malad, may I just make 1 minute submission?
Correct.
Half a second. Malad, the order of the Waqf board was not limited to the criminal proceeding. That is what I'm trying to tell your lordship, Malad. So I may show the order.
correct. So that's why with regard to
Malad, to the extent that it is not covered by the criminal part, that does not, that stay goes.
okay, in that case, I am clarifying. I am repeating the. I am reiterating the order passed by the division.
Yes, yes, Malad does that. Yes, yes. I don't have a problem.
Nothing.
That is what I wanted.
That is already there on record. That is between the parties. My lord may say that my lord has already said, kindly see the 15th December order. My lord has already said that the Honorable Division Bench has already passed.
Bench has ordered, Malad, keep
My lord,
The matter is listed as to be mentioned on the prayer made by the counsel for the petitioner. Counsel for the petitioner submitted by an order dated 15th of December 2025. This court in paragraph 6 has indicated that the Honorable Division Bench already passed an order of status quo till the disposal of the writ application, but this court has not clarified the observation made by the Honorable Division Bench in paragraph 6, the order dated 10/11/2025. Considering the submission, Learned Counsel for the respondents raise objection and submit that the order dated 15 December 2025 cannot be modified unless and until the petitioner made an application for modification of the order, or he can challenge the said order before the appeal. Had the Learned Counsel for the respective parties, this court find that the Honorable Division Bench in its order dated 10/11/2025 already clarified that inward comma. We only clarify that stay of the operation of such granted by the learned single judge shall not stand in the way of the Vakra court and oblique or state initiating criminal action against the writ petitioner if they are otherwise entitled to do so. In view of the above, the portion of the said order is incorporated in the order dated 15 December 2022.
And my lord may add that parties shall abide by the division bench's order. My lord may add parties shall abide by the division bench's order.
The parties shall abide by the order passed by the
Only
honorable.
one
My lord.
May I just make one
My
submission?
lord, my lord, I am for the state, my lord, kindly record my appearance.
Only one submission, my lord.
On 15/12, on
That's
15/12/25,
But
there is
the
a order
part
passed by my lord.
Yes, they want some order against the division bench's order. That is the sole purpose.
But then kindly,
Grateful to Lord, sir.
My lord, our order is passed on 15/12. My name was not recorded. Kindly record my name, my lord. I am appearing for the state, my lord, Vijay Agarwal.
My lord, I am appearing for the respondents.
Item number
Sir,
7.
my first submission would be, my lord, your lordship has not a determination to take up this matter.
This matter?
This matter.
What is the prayer?
My lord, prayer permission, he is asking for permission for using the microphone. That permission only can be given by when a police has given the no objection certificate for holding the meeting. Here, my lord, very camouflagely this petition has been made, and I will make another. These lawyers are forum swapper. Earlier, when the bench was comfortable, the police inaction matter, they have moved it. Now they are thinking that this court is very friendly to them, therefore they are moving it.
Not to say that the court is
Friendly, comfortable.
Court is friendly to all advocates.
My lord, no.
As per as
The
my
order,
knowledge.
so far the order is concerned. When
As
the
far as this court is concerned, this court is friendly to all
All-
advocates.
well,
of
now
the-
the
if anybody is telling that I am not or the advocate is not comfortable.
no, that's I know.
It is open to the advocate.
I did not want to say in that way. I am saying forum shopper. Forum shopper means the determination is concerned.
That is correct.
That I can say always. That I can say always, my lord. Here, police have been made party. Police no application has been made to the police authorities. Unless police is given the no objection certificate, the question of granting the SDO permission doesn't come. Then, my lord, I am so far determination is concerned. Your lordship knows, my lord, do not take it otherwise. So far the friendly is concerned. I am not saying. I am saying that I am saying in a different. My lord is more liberal. That's kind of I can say. My lord is more soft. That's much I can say. My lord is more gracious. That's much I can say.
Okay, what
Okay.
the matter?
And now kindly see, my lord. I am sorry that I'm reading from here, my lord. 1989 SCC online Calcutta 224. I'm sorry, just now I have been briefed in this matter. And
1989 Calcutta?
SCC online Calcutta 224 equal to AR 1990 Calcutta 168. Now, my lord, the paragraph Paragraph 18 of the judgment, my lord, I just read it. It is thus clear that the Chief Justice of the High Court has the constitutional power to determine what judge in each case is to sit alone and what judges of the court, whether with or without the Chief Justice, are to constitute the several divisions court. In other words, the functions of assignment of judicial business amongst the judges of the High Court, whether sitting singly or in the division court, is entrusted by law to the Chief Justice, and the judges of the judges derive jurisdiction to deal with and they decide the cases or classes of the cases. The power is derived not only from the provisions of the section
That is settled law.
settled law. Determination is
settled
settled law.
law.
And that is also, my lord, reaffirmed. Now, my lord, kindly see, police has been made party.
prayers have been made, the prayers have been made to effect your lordship's order to the police authorities also. Although police has not given any no objection certificate. And he is as if, my lord, as if there, my lord, is a very camouflage. Kindly come to page 17.
Yes, I want.
Issue a writ or in the nature of mandamus commanding the respondent number 2 to 4 to grant permission to the petitioner and his organization to use microphones and speakers during holding the meeting which is scheduled to be held on 24 so and so at Sagar so and so. B. Then C. Issue a writ in the commanding the respondent authority to ensure that no hindrance. So who will ensure?
Yes.
That is not the SDO, that the police. Two things. So far, unless a permission from the police is there, the granting of the using of the microphone by the SDO doesn't arise. So far, my lord, the law and order, it is a completely law and order that is vested with the police. Police can assess where it can be done and where it cannot be done. No application to the police authorities. No assessment has been made. Now, I'm asking a relief against the police authorities.
Yes.
And whether kindly do not take me amiss, so far the police party is concerned.
The police, that on last occasion also say, with regard to the police, this court is not having the determination. But with regard to the SDO.
SDO loudspeaker when it is given.
With regard to, because kindly see the prayer B is with regard to respondent number 2 is the SDO.
SDO.
Correct. So the police has to submit the report to the SDO and the SDO.
No. Then first is no objection certificate has to be taken.
Correct.
Then the microphone. He is jumping on the second first, leaving aside first part. And all these types of matter, kindly excuse me, my lord. All these types of matter, these lawyers have moved before the police that determination. Suddenly, my lord, it has now been changed.
Okay. Yes.
Correct.
And merit, I will speak later on.
Yes.
With your lordship's kind leave, my lord. My lord, brushing aside the personal aspersions, my lord, which are directed towards me, my lord, the lawyers. But I would address your lordship, my lord, only on the point of law, my lord. But I can also produce, my lord, identical orders where, my lord, the police in action bench has been moved, where meetings and rallies are on public places, on public lands, my lord. And there comes the question of permission, my lord, under section 30 of the Police Act, my lord. My lord, the primary prayer, my lord, is directed as against the inaction of the SDO, my lord. If my lord kindly takes the Code of Civil Procedure for once, my lord. Rule 53 of the writ rules makes the CPC applicable to writ proceedings. Now kindly takes order 2, rule 1. CPC also. Now kindly takes order 2, rule 1 of the Code of Civil Procedure.
Yes.
That speaks about the suit to include the whole claim,
Yes.
including the primary relief, my lord. The primary relief is as against, my lord, the inaction of the subdivisional officer in according necessary permission
Yes.
to us to have a public meeting
Yes.
by way of using loudspeakers and microphones on a private plot of land, admittedly private, my lord. I have annexed, my lord, the record of rights also and the no objection that we have obtained from the landowners also, my lord. So that is the primary, my lord, relief that I have claimed for. And my lord, order 2, rule 2, sub rule 1 will possibly, my lord, set at rest, my lord, the objection taken on behalf of the state. It has to include everything, my lord.
Yes.
Now, my lord, in terms of section 34, police sector. In terms of, my lord, section 34A, my lord, a copy though, of the Police Act.
Yes.
Kindly bear with me for a moment. I'll just place the relevant. Yes. It's a state amendment, my lord, a West Bengal amendment.
Yes.
So it speaks about power to prohibit, restrict, regulate, and impose or impose conditions.
Which section you are?
34A, my lord, capital A.
Yes.
Yes, it's a West Bengal amendment, my lord. If in the opinion of the magistrate of the district or any subdivisional magistrate or magistrate of the first class, it is necessary so to do for the purpose of preventing annoyance to or injury to the health of the public or any section thereof, or for the purpose of maintaining public peace and tranquility, he may, by order, prohibit, restrict, regulate, or impose conditions on the use of operation in any area within his jurisdiction or in any vehicle within such area of microphones, loudspeakers, or other apparatus for amplifying human voice or for amplifying music or other sound. Thereafter, my lord, 34A subsection 2, the state government may, on its own motion or on the representation of any person or persons aggrieved, modify, alter, or cancel any order made under subsection 1. Thereafter, subsection 3, a police officer not below the rank of sub-inspector may take such steps or use such force as may be reasonably necessary for securing compliance with any order made under subsection 1 or any such order as modified or altered by the state government under subsection 2, and may seize any microphone, loudspeaker, or other apparatus used or operated in contravention of the order. So, my lord, the role of police arises only after formation of opinion by the magistrate or the subdivisional magistrate, my lord, and thereafter, upon, my lord, any modification, if any, by the state in exercise of powers under subsection 2, my lord, of this particular act, my lord. So, my lord, as submitted, my lord, that the police has to give a no objection, only thereafter there will be the SDO's permission, my lord. That is alien, my lord, to the concept of the state amendment. This is a state amendment, my lord. It is not, my lord, the central amendment, my lord, or any provision, my lord, from the Police Act. It's specifically for West Bengal, my lord. So, my lord, I am submitting.
Yes, good.
73(1) is this.
Yes. Yes.
Now, my lord, the second contention about forum shopping, that similar matters were being moved, etc. As I submitted, my lord, there are matters galore, wherefrom, my lord, it will be demonstrated that the police inaction bench was moved whenever meetings and rallies are on public places, on the roads or on the public roads, public streets, my lord. And very recently also, my lord, even last week also, my lord, we have moved such similar matters, my lord. Now, my lord, my lord, establish, my lord, that the question of police permission or section 30 will not come into play when it is on a private property. My lord, may kindly take, my lord, section 30 of the Police Act for once.
Yes.
Section 30 says, regulation of public assemblies and processions and licensing of the same. The district superintendent or assistant district superintendent of police may, as occasion requires, direct the conduct of all assemblies and processions on the public roads, may kindly mark, public roads or in public streets or thoroughfares, and prescribe the routes by which and the times at which such processions may pass. So, it is essentially for public roads, public streets, and public thoroughfares. He may also, this is subsection 2, on being satisfied that it is intended by any persons or class of persons to convene or collect an assembly in any such road or street or thoroughfare, or to form a procession which would, in the judgment of the magistrate, again, my lord, of the district or of the subdivision of a district, if uncontrolled, be likely to cause a breach of the peace, require by general or special notice that the persons convening or collecting such assembly or directing or promoting such procession shall apply for a license. So, my lord, this is the law, my lord, regulating meetings at public places, my lord.
Yes.
And private property, my lord, there is no concept, my lord. The Police Act does not apply, my lord. If the Police Act does not apply, the Police Regulation of Bengal also does not apply. And the provisions contained in the Police Regulation of Bengal are also, my lord, pari materia, insofar as this is concerned, my lord. My lord, to bolster the contention, but I will be referring to, my lord, an observation made by the Honorable Supreme Court of India in a judgment which is reported at 1973 1 Supreme Court cases, page 227. The relevant paragraph is, my lord, paragraph number 35. Yes. My lord, may kindly, my lord, take the paragraph. What's up? Eta আছে না Xerox আচ্ছা এটা দিন কোনো অসুবিধা নেই Para 35, my lord, says that if the right to hold public meetings flow from Article 19(1)(b) and 19(1)(d), it is obvious that the state cannot impose unreasonable restrictions. It must be kept in mind that 19(1)(b) read with Article 13 protects citizens against state action. It has nothing to do with right to assemble on private streets or property without the consent of the owner or occupiers of the private property. So, my lord, this is the law.
Yes.
Pursuant whereto, my lord, we are before your lordship because I cannot go to the police in action bench, my lord. I cannot go to the police in action bench, my lord, and my lord, I refrain, my lord, from offering any comment or any response, my lord, to the personal aspersions, my lord, about forum shopping or all. I practice with responsibility. I know my duty very well, my lord, and I argue only on the question of law, my lord, only on the point of law. My lord, here, coming back to the case, my lord, the intimation was given on 17/12/2025. My lord will find the intimation at page 28, my lord. I'm sorry, my lord. The intimation is at page 25.
Yes.
28 is a copy marked to the police authorities also for intimation, advance intimation.
Yes.
There was a submission that nothing to the police, etc. So this is the intimation. The meeting, my lord, is scheduled on 2/1/2026. I'm sorry, my lord. Meeting scheduled on 24/12/2025. The time of the meeting is 12 noon to 6 p.m. The total area of land, my lord, is 2.33 acres. The expected turnout, my lord, is 10,000. It's a meeting, no rally, my lord. The total number of microphones and speakers, my lord, that has also been indicated, 100 microphones and 8 speakers. And my lord will find the no objection from the landowner, my lord, appended at page 23, my lord. 23 contains, my lord, the no objection, and page 24, my lord, contains the record of rights, my lord.
Yes.
After that matter, I am personally now checking up about, my lord, the landowners and the plot numbers, my lord.
Yes.
So it's a 2.33 acre property. It's a private property in the name of Shanti Shankar Giri. My lord will find the NOC at page 23.
Yes.
And my lord, the intimation given to the SDO has not been responded to, my lord.
Yes.
So, my lord, these are the facts, my lord. Now, my lord, even in even in case of, my lord, meetings which are held on public properties, for example, my lord, the Brigade Parade Ground, my lord, the law is very well settled that if any political party, a recognized political party, unless de-recognized, if they intend to have a meeting even on a public place, the police cannot impose any restriction or unreasonable restriction. But I am referring to, my lord, this is 1993 1 Calcutta Law Times, page 436, corresponding to 1993 volume 1 Calcutta High Court Notes, page 450. Eta konta dile? I'm sorry, my lord, I'm sorry, my lord. The division bench judgment. That is the. This is 1993 1 CLT page 464. কি করছো আমার কপিটা দাও ভাই Yes. Madam, kindly take paragraph number 4, my lord. The learned judge has also directed the Commissioner of Police to grant permission sought for, this was on the brigade parade ground, sought for by the Bharatiya Janata Party, but he has, however, clearly pointed out that the Commissioner may impose such regulatory measures as he would think fit for the proper maintenance of law and order and public peace. Here, my lord, there was a 144 order issued by the Commissioner of Police in light of, my lord, the incident that took place, my lord, on the 6th of December at Ajodhya. So thereafter, my lord, the meeting was thought to be, my lord, restrained by the police by exercising powers under 144. So that was challenged. We are, however, of the view that such a direction can be given in appropriate cases by a writ court, and the decision of the Supreme Court in Comptroller and Auditor General of India versus, this is K.S. Jagannath's case, is a clear authority for this view. We are inclined to hold that the learned judge has only reiterated what Article 19 of the Constitution of India provides in express terms, namely reasonable restrictions on the exercise of fundamental rights in the interest of public order and for maintenance of public peace. We do not think, from all that we see at present, that the order suffers from any infirmity or illegality which requires intervention at this stage before we can hear the appeal. So, my lord, this is the principle which governs, my lord, meetings on public places also. And here I have satisfied your lordship, my lord, it's on a private property. There is no rally, my lord, or no procession. Therefore, my lord, the question of, my lord, crying hoarse about police inaction by approaching, my lord, the bench, exercising determination under Group 9 having police matters, my lord, that does not arise, my lord. And my lord, I am fortified by similar orders passed by your lordship, my lord, order the similar order. So, my lord, I will be referring to, my lord, one such order. Oh, right. This is a problem. Well, these are my humble submissions.
Finally, see first the prayer A, your lordship has seen that I will come to that.
Yes.
Next prayer C. Issue a writ of or in the nature of mandamus commanding the respondent authorities to ensure that there are no hindrance and or interference is caused to the petitioner and his organization in any manner whatsoever while conducting the said meetings. Who will cause the hindrance? Have they said in the petition?
Yes.
He will hold a meeting in his private land, very good. But I have to take responsibility of entire crowd. Holding a meeting in the private land, I have no problem. Do it. You bring 10,000 by aircraft. I don't mind. But if the road is blocked, where the car will be parked? In ingress, if the traffic movement is stopped, the police will not take any steps because the opposition leader is coming. Is there any special law for this in this state for the opposition leader?
Yes.
This entire crowd will come. Then will delete the all police persons' names from here. Delete and hold it. The police will not be responsible for anything as is done.
Yes.
And they will cause all this in a public, private land, private property. 10,000, 50, even in a marriage ceremony, if there is a crowd to certain extent, everyone has to inform the police.
Natural.
Well, ultimately, responsibility will come to me. I am not asking for anything against the police. What is this?
No.
An officer, subdivisional magistrate will act on the basis of certain ground reports.
No, Mr. Bhattacharya, the report he has applied before the subdivisional officer.
Correct.
Correct. If the subdivisional officer has received an application, what report is required? It is up to the subdivisional officer to either reply to the petition. Yes, I have
correct, absolutely
report against you with the negative report against you, so that the cannot be granted.
Correct, my lord.
If it is filed, so it is the subdivisional officer. To
my lord, can I see the modus operandi in all cases?
A representation is made 5 days ago. This program must be have decided long back. 1 month, 2 months back, they should have asked for it. What are your lordship is saying? Now SIR is working, going on. What the subdivision officer will do? He will do in terms of the works of the election commission or the desire of them. Entire
But the officer also cannot say I am busy.
No, I am not. No, cannot say. A reasonable. If I come with 100 petitions, your lordship will decide.
That's why.
Kindly see.
That's why yesterday I passed an order calling a report from the commissioner as well as the home secretary home. What are the guidelines you fix? What is the time frame the application is to be filed? What are the reports what are the documents? Because no guidelines is fixed. So
I understand. Even then, the no guideline is fixed. Court will presume the. Kindly do not take it. Again, I am. Court will take the assessment of this section 34(1). Here is a. See first. 34A.
Yes.
If in the opinion of the magistrate of the district or any subdivision magistrate of the person is necessary to do so for the purpose of individual, their opinion has to be formed.
Correct.
Whether court will form the opinion.
That's why. That's I'm telling.
No, I understand.
Court cannot opinion. That's why the what the SDO requires for giving the
exactly. Your lordships kindly see, appreciate this. Appreciate this. In every matter, we are not getting any chance to file an affidavit.
Correct.
And any matter, we are not getting the chance even to prefer an appeal.
By the time the
meeting on the just their approach, modus operandi is this. This is the modus operandi. The meeting before 1 day, kindly grant me leave. Your lordships have granted leave with your lordships' kindness. In this process, state is denied the right to justice. I have also right to file an affidavit. Your lordships will kindly see why your lordships do not take it. Anything. Your lordship also should not decide the matter without any affidavit. Or any interim order should not be passed. Because if the interim order is passed, everything absolute.
Correct. The court never passed interim order if the other party wants.
But in one matter, I have filed an affidavit. I got it. Justice Titonkor Ghosh was there. He was there also other side. Dismiss the petition.
Correct. So that's why the state wants to file. But the time is so short.
No, therefore, why? That is the reason why. Please. I have not finished it.
I have not said anything.
No, you are standing.
There was a query I expected from the honorable judge. I did not say anything. I did not interrupt.
These lawyers are having the privilege over the Calcutta High Court in every court. Because he is appearing for Subhendu Adhikari, therefore he is having a privilege. Yes.
Before this court, not to make any allegation against each other, please.
Yes,
Whatever the grievance, please place before.
Whenever he has nothing to say on the point of law, he casts personal aspect.
Yes. You are master of law. You are master of law. You do not know anything. You don't have any brief accepting BJP.
Very well.
Yes.
I'm very happy with that.
Yes, happy with that.
Yes. If that is so, then I'm happy with that.
Yes.
Please address the honorable court.
You will not tell me what I will do.
Don't threaten me.
Don't do it.
Don't threaten me. Don't threaten me.
Mr. Bandyopadhyay, sorry. This court will not allow this type of the practice.
No,
before this court, whatever you want to make a submission, please.
I will make this submission.
Not to make allegation and not to put a finger to the other advocate.
No, do not.
He's not telling anything. A court is here. Please, whatever please.
What is this?
Court is hearing the matter. Court is hearing the matter. Why you both are fighting each other?
No, when he was arguing, I didn't say anything.
Senior person.
Well, kindly appreciate. Kindly appreciate. When he was arguing, I didn't stand. What is this? When I am arguing,
the court is
no.
Court has directed him to sit. Take the seat. Please, you complete. You
are saying every court I am facing this rowdyism. That's much I can tell you.
You can see who is.
Yes, rowdyism. Yes. Rowdyism I can see.
There used to be a time when we used to take you seriously.
You don't take me seriously.
Respect you.
You don't know. You don't. I don't need your respect.
Please,
You are the
please,
person who is not known to anyone,
There
even
are-
in your para.
there are other matters.
And your neighbor. Yes.
you so much.
Yes.
Yes,
Now, my lord, kindly,
Section
what? Section 34.
yes, section 34A.
34, yes. If in the opinion of the magistrate of the district, some persons are being frustrated because their names are not considered for elevations. If in the opinion of the magistrate of the district or any subdivisional magistrate or magistrate of the first class, it is necessary so to do for the purpose of preventing annoyance or injury. Therefore, an opinion is to be formed. Now, this petition has been given on 18th, received it on 18th. Kindly come to page 27. December, first letter, subdivisional officer. Then nothing, no stamp, nothing. Now, email is 27, page 27, 18. 19th to Saturday. 80 that has been sent at what time? Right at 10:20. That's got it? 10:20. Then the Millard 1920 holidays. 19th is Friday. Saturday, Sunday, 21st holidays. 22nd, leave has been granted. So where we are getting the time?
Yes.
Milord, kindly excuse me. Kindly do not expect me, Milord. Whenever a representation is there and High Court is entertaining all this petition, that I have to work in the overnight.
Correct.
Where is the formation of opinion? Now, Milord, kindly come now. The petition. See paragraph 3. Paragraph 4. 100 microphones. I don't know whether your lordship is having any idea of 100 microphones. 100 microphones means it goes at least in all sides at least 5 kilometers. At least. And 8 speakers will be used strictly in confidence of the prescribed decibel limits. Did they take any certificate from the Pollution Control Board? And 100 loudspeaker cannot be within the decibel, 65 decibel.
Correct.
Then, Millard, kindly come. See, there is no allegations against any persons who will create hindrance. Millard, I hope that the court will not suggest at all, at any point of time, the public property, public road, there would be thousands parking without having any permission, or haphazardly it will be done. But simply because he has come to court, that is not the point. Court will also take into note those who have not come to court, their peace, their tranquility.
Correct.
But only to establish his fundamental right. Others' fundamental rights cannot be demolished or destroyed. Simply because he has approached the court itself.
So, to cut short the matter, he prayer be with regard to the subdivisional office. Correct.
Correct.
Rightly or wrongly, this court is having with regard to the prayer B having the determination. Correct. So what I propose, suppose
My lord, my lord.
I will direct the sub-divisional officer to consider if he receives all the report.
Yes, yes, I have no objection.
So because
I am not.
court is not passing.
No, I am not opposing that. But kindly restrict this petition only to the prayer A, B,
prayer B.
not this other prayers.
B. In the last occasion also, Mr.
And my lord, my junior has said to me regarding the formulation,
Yes,
give me these Christmas vacations and give me 7 or 10 days more.
No, I
I
have fixed in the 26th.
yes, I'll be talking with the chief secretary and I will do something because that was exactly what this thing was said observed by the Justice Ghosh. Kindly do not misunderstand me.
Nothing. See, the court has to hear all.
Do not misunderstand me.
Court has to hear all the. But
Yes.
one petition has come to the court. Court has to decide
Yes.
any other way. Now, you have taken the stand. Now, with regard to the prayer B, this court find that this court is having the determination. With regard to the prayer C, and this is the sub-divisional officer has to take as per the section.
Formation of opinion is needed.
Section 34. Let the sub-divisional officer take a decision.
My lord.
Take a decision. Yes, Mr.
By tomorrow morning, he will take the decision because tomorrow meeting is there.
Yes.
Bro, we have to communicate.
A short response, my lord. But nothing alleged against anyone, my lord. Para 14 and para 19, my lord. That culminates to, my lord, prayer C.
Yes.
Page 8, para 14, the petitioner submits that the sole motive behind the non-action on part of the respondent authorities is to somehow stop the petitioner's party from holding the said meeting on 24/12/25. It is apposite to mention herein that it has become a regular modus operandi of the respondent authorities wherein they sit tight over the representation and or intimation and only reject it at the very last moment so as to prevent the aggrieved person from knocking the doors of justice. Thereafter 15, the petitioner submits that it has become a convention in West Bengal that political parties in opposition have to knock the doors of justice in every such cases seeking permission to conduct a rally or procession or any political program or meeting. Thereafter, para 19, the petitioner submits that despite receipt of the said letter dated 17/12/25, wherein an application for using microphones and speakers during holding the said meeting has been.
Okay, Mr.
The respondent number 2 is maintaining no, it is stated and apprehended.
Correct, Mr. Bhattacharya. This court is not going into that fact. Otherwise, then.
No, my lord, kindly appreciates, my lord, my concern, my lord. My lord, if, my lord, the SDO rejects the permission, my lord, despite this order, which they will do, my lord, this is what also, my lord, is apprehended in the petition. My lord, I will be non-suited, my lord. 24th is the meeting, my lord. And my lord, in so far.
That's why, see, you have applied on 17th.
My lord.
But the 17th with the 23 page number 25.
18th is the email, my lord.
18th.
It is dated 17th, 18th it was sent, my lord, as I find.
You have mailed.
No, I'm sorry, my lord. 17th it was mailed, my lord.
No, where is the
page 30?
Page 30.
My lord.
Page 30 is the 18th.
Wednesday, 17 December, my lord. Page 30.
December 9.
30A is, my lord, 18.
Correct. 30, that is 17 in the night.
In the night.
17, 10:30, the 17 is the, was the, on Thursday, Wednesday. So 18, 19, 2 working days was there. Then.
No, yesterday was a Monday again, my lord. Now, my lord, kindly, the other concern of the state that about who will regulate the traffic, what will happen, etc., etc. Not for that, Section 33 is there in the Police Act. My lord, kindly take Section 33. That is independent. That is independent of 34A as well as 30. So 33,
yes, saving the control of the magistrate of district.
I'm sorry, my lord. 33. I'm sorry, my lord. 31. Police to keep order in public roads. Section 31 shall be the duty of the police to keep order on public roads and in public streets, thoroughfares, ghats and landing places, and at all other places of public resort, and to prevent obstructions on the occasion of assemblies, processions on the public roads and in public streets, or in the neighborhood of places of worship during the time of public worship, and in any case where any road, street, thoroughfare or landing place may be thronged or may liable to be obstructed. So that power is already independently available. But the police cannot say, but that we will abstain from performing our duties, which otherwise we are statutorily bound to do. But this is an independent provision. So, my lord, for granting a permission by the SDO But this cannot be followed. This can, my lord, be implemented only once, my lord, there is an obstruction. And here, my lord, can record my undertaking, or rather it is there also from the records. It's borne out from the records also. There is no question of any rally or procession. Villagers, it's happening in one in Malda, the other one is in Sundarban district, my lord. Most of them, my lord, either walk or use bicycles, my lord.
Okay.
My lord, I will be praying for, my lord, and my lord, it was submitted, my lord, that the state is deprived, my lord, from filing appeal. And last month also, my lord, 2 appeals were filed, my lord, before the Honorable Division Bench, my lord. Same set of lawyers, my lord. My lord, the Honorable Court, my lord, in one matter, my lord, there was a consent order, my lord, insofar as the date of meeting is concerned. It was on a public road, though. And in the other matter, the appeal was dismissed, filed by the state, my lord. I have the copies. I can hand it up also to your lordship, my lord.
Yes.
Let us give a chance for filing an affidavit. Thereafter, your lordship will allow his petition.
But in the meantime, my lord, I'm pressing for the interim order, my lord. My lord,
That
passes the
case, in
interim
that
order.
case-
My lord, relying on Devraj versus State of Maharashtra, my lord, reported in AIR 2004 Supreme Court, page 1975. And I'm pressing for the interim prayers, my lord.
In that case, you can file, but the
Yes.
interim order, if it interim order, then
No, your lordship has already proposed an order.
correct. That's what I'm telling.
No, he is talking about affidavit. That's the reason. Your lordship has proposed an order. Thereafter, I have not argued. Thereafter, I have not argued. The moment your lordship has proposed an order, why should I? My lord, I don't have quarreled with the court.
Neither the court is having any personal interest in
Right,
any
right.
of the
I don't have. Why should I?
Neither the
My lord,
court is having any
yes,
personal
and
interest in
lo-
any of the
I have
court,
only.
court has to
My
give the
lord,
justice to all the parties.
kindly remember, my lord, also only appeal. Court will also look into the other interest also, not the only this interest.
The petitioner has filed the present application praying for a direction upon the respondent number 2, the sub-divisional officer. Sub-divisional officer, Kagdeep, district South 24 Pargana, South 24 Pargana, to allow the petitioner and his organization to use microphones and speakers during holding the meeting, which is scheduled to be held on 24th of December 2025 from 1200 hours to 1800 hours at Sagar, Rudranagar, Charangi, situated in Mauza, Rudranagar, Dag number 4277, Khaitan number 1993, Police Station, Sagar, District South 24 Parganas. Fully confirmed for the petition submitted. The petitioner intends to hold the meeting in the private property, and the person who is the owner of the property has already given no objection for holding it. He submitted on 17th of December 2025 by way of email. The petitioner has applied before the subdivisional officer for grant of permission, but till date the permission has not been granted. Petition has relied upon section 34 capital A of the Police Act 1861 and submits that it is the power of the magistrate of the district or any subdivisional magistrate or the magistrate of the first class if it is necessary to do so for the purpose of preventing any annoyance or to injury to the health of the public or any section thereof, for the purpose of maintaining public peace and tranquility, he may, by order to prohibit, restrict, regulate, or impose conditions on the use or operation in any area within his jurisdiction or in any vehicle within such area of microphones, loudspeakers, or other apparatus for amplifying human voice or for amplifying music or other sounds. He submits that the subdivisional officer is the competent authority for grant of permission, but till date grant of permission under the said provision. He submits that the petitioner is not praying for any relief against police. He has further relied upon the judgment in the case of Himmat Lal K. Shah versus Commissioner of Police, Ahmedabad and another, reported in 1973 1 SCC 221, and submit that the Honorable Supreme Court categorically held that the right to hold public meeting flows from Article 19 within bracket 1 within bracket small b and 19 within bracket 1 within bracket d. It is obvious that the state cannot impose unreasonable restrictions. It must be kept in mind that Article 19(1) within bracket b read with the Article 13, protects citizens against the state action. It has nothing to do with the right to assemble on private streets or property without the consent of the owner or occupiers of the private property. We submit that in the present case, the petitioner has applied for permission to hold the meeting in the private land, and the land who is the owner of the property is already given the no objection to conduct the meeting. Police. Per counter, learned senior advocate Mr. Kalyan Banerjee, appearing for the state, has raised the preliminary objection with regard to maintainability of the writ application. He submits that if the grievance of the petition along with the prayer is read together, he submits that the writ petition is not maintainable before this court as this court is not having the determination to decide to pass any order for inaction or non-action on the part of the police authority. He further submits that the petitioner has applied for grant of permission on 17/12/2025 at 10:32 hours and without giving any and immediately on when you file the writ application and immediately on 22nd of December 2025, the petitioner has filed present application present application without giving breathing time to the authority to consider the request made by the petitioner for grant of permission to the petitioner for holding meeting. Police. This court find that this court find the prayer B. In prayer B of the writ application, the petitioner has prayed for a direction upon the respondent number 2, who is the sub-divisional officer. Police. Prayer C. In prayer C, the petitioner has prayed for an order for directing the authorities to ensure that no hindrance or interference is caused. Mr. Banerjee contention is that prayer C, if the prayer C is to be taken into consideration, the only police authority has to ensure any hindrance or interference cannot be caused when the petitioner will conduct the meeting. And as such, the prayer C is connected with the police authority. Police. Heard the learned counsel for the respective parties. This court finds that the petitioner has made an application on 17th December at 10:30 p.m. through mail. Police. And subsequently, the authorities have not passed any order either rejecting or allowing the prayer of the petitioner, and the petitioner has filed the present application. Prayer B is prayer B for the direction upon the sub-divisional officer to grant permission to the petitioner for holding meeting on 24/12 from 12 hours to 1800 hours. Full stop. It is the prerogative of the respondent number 2, that is the sub-divisional officer, to consider the request of the petitioner and to grant permission, or it is the prerogative of the respondent number 2 to consider the application of the petitioner whether the petitioner is entitled to get the permission for holding meeting or not. Full stop. Whether any information and thing is required by the sub-divisional officer, he could have been asked the petitioner or to the concerned authority. This court finds that the sub-divisional officer has not made any communication with the petitioner with regard to any further information. Considering the above, this court finds that the petitioner has filed this application. This court finds that prayer B is only with regard to the direction upon the respondent number 2 for grant of permission, which is within the determination of this court. Accordingly, this court disposed of the writ application directing the respondent number 2 to consider the application filed by the petitioner on 17th of December 2025 and take appropriate decision and to communicate the same to the petitioner by
But tomorrow
is the meeting.
But today night, is it possible?
By today night 9 p.m. at on or before 9 p.m.
By 10 p.m.
10 p.m. Take decision and to communicate the petition to the petitioner on or before 10 p.m. on 23rd of December 2025.
To the same email.
To the same email which the petitioner has mentioned in the application dated 17 December 2020. Petition is. Thank you.
But next one is the date is 2nd January. Kindly that instead of today, that kindly
next
do
one, na? Same karo. That's the
26.
same.
Yes.
For 18th is the date of the application, and the meeting is on the 2nd of January 2020. Date of application 18, page 31.
19. Anyway, that's not the point, Miller. 19. Give me on 26th we will communicate.
Next one, me. Apply meeting. Just a minute.
Yes. Here, my lord, the application is at page 31.
Second meeting on 22nd January 20.
No, meeting on the 2nd of January, my lord.
2nd of January
2026, 1300 hours to 3 p.m. 1500 hours, 1300 hours to. Okay. And attention from the and filed an application on 19th.
My lord, 18. Application
received on 19.
File.
Page 27.
Yes.
Filed an application on 19th to take approval. Baki वही सब आ जाएगा. Take the decision and to communicate the same to the petitioner on or before 26th of December. 27th. 25th is the.
By 26th.
By 26th December.
26th because thereafter.
But the application was made via email on the 18th itself, and the physical copy, my lord, was received on the 19th.
My lord, I hope, my lord, your lordship has seen that, although it's not purely applicable, but the provision in the BNSS that even the electronically, if any FIR is lost, is information, he has to come and give it personally.
Okay.
Of course, it is on different contexts, but not by on the email.
Correct.
No, Karan, why nobody knows whether I am not saying that he is there. In other cases, someone may misutilize it.
Yes, that is necessary.
That is necessary.
That is necessary to give an affidavit. No criminal cases.
And so far that proposal of your lordship,
please.
I am seriously considering.
I hope you will take care of it.
Yes. Just give me some times.
That's why I fixed on 22nd January. You take.
After long days.
I have an opportunity to hear all of you.
I have the opportunity to see you. I don't get.
Thank you.
Opportunity. Your smiling face. Keep love.
Thank you.
Grateful to your lordship.
Thank you.
Police Act.
ये फाइल में रख दो.
The petitioner in item number 8.
My lord, I appeared in item number 7, my lord. Kindly, as I told before, my lord, I have appeared on 15/12. Order is passed, my lord. My name is not recorded. Kindly,
item number 11.
Item number 7, my lord. 7. Item number 7.
कौन सा item है? Yes. Who is appearing for the item number 8?
For the petitioner.
Yes.
I am for
This is a
my lord, kindly record my name in number 7, my lord. As well as on order passed on 15/12. 15/12 an order was passed, my lord. My name is not recorded. Kindly record.
So this was dismissed, and it was the order was passed on 24/10/25.
Where is the order?
Page 12.
Page 12 of the can.
Yes, sir.
Where is your can? Page 12. Yes, why you not appeared? Why you not appeared, sir?
He was ill on that day.
Where you mention ill on that day? Kindly come to a paragraph 3. As none appears on behalf of the petitioner, the dismissed. Where is the cause?
Sir, I apologize. This on paragraph 5, it's written that
Yes, who is
from the
The petitioner has filed the present application praying for. Present application being can number 1 of 2025, praying for recalling of the order dated 24th of October 2025, wherein the writ petition was dismissed on the ground that the petition none appeared on behalf of the petitioner when the matter was called. The counsel for the petitioner submits that when the matter was called, the learned advocate was in other court and could not appear before this court. And when the learned advocate reached before this court, by that time the order has been passed. Immediately, the petitioner has filed an application on 14th of November 2025 praying for recalling of the order. At the learned counsel for the petitioner perused the application, this court finds the petitioner has shown sufficient cause for non-appearance of the petitioner. Accordingly, order dated 24th October 2025 is recalled. WPA 22359 of 2024 is restored in original file. In its original file, can is disposed of. Next.
Yes. This is my application for restoration.
Yes.
So, my dismissed for default on my 23rd June 2025. And there was a delay of 37 days.
Which for the state?
My lord, I am for the WBCDC led by Mr. Srijan Naik and Mr. Ponna Mitru, my lord.
Yes. What is the submission?
Let them the delay condone.
Why you not appeared?
My lord, this is a change brief. My lord, they did not appear.
Yes.
This is a change brief. My lord, say they did not appear before the learned honorable court.
The petitioner has filed the present application for recalling of the order dated 23rd June 2025, wherein this court has dismissed the writ application for default. At the learned counsel for the petition, the petitioner also filed an application for condoning the delay of how many days?
37 days.
37 days. At the learned counsel for the petitioner, peruse the application, delay is condoned. Condoned. 10 numbers is disposed of. This court finds that the petitioner has shown sufficient cause for non-appearance of the petition before this court. Accordingly, the order dated 23rd June 2025 is recalled. WPA number 11733 of 2025 is restored in original form.
Let this matter appear on 10th.
Let the matter appear on 9th of January 2026 under the adjournment.
9 January.
Yes, next.
I am appearing on behalf of the petitioner, my lord.
Yes.
And led by Mr. Bhattacharya. I believe Mr. Bhattacharya.
Yes, what is the prayer?
My lord, that matter, my lord, will remember, my lord, MG and Reka work is done.
Instruction according to
Yes.
Yes,
Lordship.
Manreka.
Listen. Lordship, there are the
Manreka matter, Lordship was pleased to pass an order that he will direct them to pay the money. Central government wanted to take instruction.
Yes.
Lordship, we are already intention to pay Manreka. Lordship, Lord, we are the step sisters. Centrally one sister and state, right? There several reminders have been given to
They are the blood sister or the step sisters?
Sisters. Lordship, because there are several reminders have been given to the state. Please give the ATR action taken report.
That does not give you a fail.
Effective within time, Lordship, number one. Number two, after that, we have several times here. Give the state account. Not within time. Lordship, as far I have the right to stop the payment. As per section 27,
And several letters has been given to them. Please keep the ATR, but they have not given within time. So that's we have the right to stop that.
Which provision you are asking
Lordship.
for? Yes, show me.
Section 27. किताब दे दो. Oh, later, yes. So these are letters. We have due to non-compliance with the directives of central under section 27, we have stopped that payment in America.
Now you will take the plea that the name has been changed. You not.
Lordship.
We are let them release the payment.
No,
We are
there
sufferers.
is a-
Let the
no,
state and the center fight amongst themselves, but our payment be released.
Let them comply with the directions. Let them comply with the directions.
Well,
Let them comply with the directions. What direction they have taken?
several reminders have been given, Lordship.
Again say, let the state and center fight. Let our my lord, the poor contractors' payment be released immediately.
Who is for the state?
I am appealing for the state.
Yes.
We have received a letter from the December 6th Lordship from the Union government asking us to file a. The state government is required to submit the labor budget proposal for the current financial year 2026 within 30 days of receipt of this communication in accordance with the HON'BLE Master Circular 2024-25, which shall be considered during the empowered committee meeting to be convened under the chairmanship of the Secretary Rural Development. This letter is issued 12/2025.
To whom it has been given? To whom is the letter was given?
Given by the Commissioner Mahatma Gandhi NRGS to the state government, Your Lordship. And Your Lordship, they have given us 1 month time to submit the report. That 1 month is completing on 5th January 2026, Lordship. And there's in that letter they have not mentioned any dues amount here. They have not asked to regarding providing any funds from the.
Kindly see the man. You have a letter dated 9th March 2022.
Yes, that's what. Yes.
You have a letter dated 9th March 2022.
They have not complied.
But recently,
Kindly see the first 9th March 2022.
Lordship, this is not the respect to this is after.
Thereafter, the entire scheme has been stopped for next 3 years. Lordship. Thereafter, by this honorable court's order, and SLP also dismissed by the central government from the Supreme Court,
that again
restarted the scheme, Lordship, and thereafter, in this month, after the passing the order of the honorable court, Your Lordship, the central government issued this letter to us to submit a report regarding
which letter? Which letter you are showing?
I am placing.
Show me that.
My learned friend is just missing. This is the respect for after 22, not for the earlier. When after the when the apex court passed, we are ready to pay.
Yes. That scheme was stopped. How you are the state government?
Lordship, this is the interest of the public, not for the state. This is the interest for the public, not for the state. The state will not give any, will not help me. They will not give the statements. This is not the excuse. You are getting the money from the center. Definitely, you should be give the statements of the account.
Just a minute. Have you submitted the labor budget?
No, that is given me 1 month time. That is expiring on 5th January. Lordship, this letter issued on 6th December.
In view of the compliance of the direction of the Honorable High Court, Department of Rural Development, here is resumed the prospective implementation. State however, the resumption.
This is the last communication received from the Union government.
My lord, we have given the first action 6th March 19, and after that 23rd April 20. And after
so
that,
I am passing an order. You submit the labor budget proposal within 2 weeks.
And the reports.
Non-compliance.
5th January. You submit the report.
For the non-compliance, they are not compliant till today.
What?
Don't know.
What non-compliance, sir?
They have not complied because we have several letters we have given. It has not been given to me the file every opposition.
You have a letter dated 6th of December 2025 issued by the secretary to the
that we say. Regarding not that I've just received, but we have given that earlier regarding 19, 20, 23rd April 20, 15 May 20,
and 16th October. We have given the directions. Please give me all the statement, but they have failed and neglected to pay them.
Child stay for next 3 years. Stop the scheme. So you do one thing. Yesterday, reason I directed to take instruction. You coming with the one or one
আরে
paper.
ভাই এখন আমি ব্যস্ত আছি কোর্টে
Short
যখন তখন
report.
ফোন করলে
When you tell me when you come with a short report, I'll serve the copy to
So,
the
Lord,
other
you
side.
4 weeks time.
Not 4 weeks. You serve the short report to the petitioner by 5th of
In the form of the
January,
affidavit.
and you give the reply by you give the reply by 6th of January. By
Lord,
8th of January, I am fixing on 12th of January.
Lordship, this is winter is going down. Sir, give me a working
What
day.
is going on?
2 weeks. From 2 weeks time will be given.
That's why 2
after
weeks.
after the winter, after the vacation. Lordship,
What vacation in there? And in the central government, there is no vacation except the Delhi, our Calcutta High Court. There is no vacation in any other court.
Sir, after one week.
Today we are on 24th, 23rd, correct? So I am giving a time till 5th of January. You file the report by way of a short affidavit. Supply the copy to the petitioner.
But given evidence action given to me. For the evidence opposition given to me.
What?
Evidence opposition filed to regarding this.
Not affidavit opposition, on the report by way of an affidavit. What you are submitting?
Lordship.
Report by way of an affidavit by January by supplying the copy to the petitioner as well as the state respondent. The state respondent is directed to file the reply, if any, by 12th of January. I am fixing the matter on 12th is holiday. 13th? 13, no? By 13 January. I am fixing the matter on 15 January.
Very well.
Clearly at the top. No,
Yes, yes.
Great.
Yes, Mr. Bhattacharya?
Right. Okay.
Lordship, earlier my name was not recorded.
You give the name in right.
Earlier.
By an order dated. Order dated. The matter was listed on 12/12/2025. The London advocate appearing for the Union of India prays for time for taking instruction. Today, the London advocate appearing for the Union of India has brought some document and submit that the state government has not complied with the direction and has not submitted the proper document to the government, to the central government for release of the fund. The state government denied the same. Considering the above, this court find that the central government is required to file a report by way of an affidavit. Let the report be filed by 5th of January 2026 after serving the copy to the London Council for the petitioner as well as to the London Council for the state of West Bengal. The petitioner as well as the state of West Bengal is at liberty to file reply, if any, by 13th of January 2026. List the matter on 15th January under the same heading for further consideration.
Lordship, earlier order, my name was not recorded.
Give the name. What is your good name, sir?
Ajit Kumar Chaubey.
Sons. And next.
But one line maybe added, my lord, fairly at top, my lord. It will be kind enough, my lord.
John Mosen at the top.
Great,
yes.
Grateful. I extremely grateful.
Next.
I'm for the petitioner, Lordship. Lordship, suddenly on 4th of September, my prayer is to restore the electricity connection.
Yes, you are appearing. Why?
For the state
Which
respondent.
for the state of the electricity? Have you served?
Yes, Lordship.
Where is the affidavit of service?
There's affidavit of service.
Yes.
Lordship, suddenly on 4th September, I received a communication from the electricity department that one bill is raised 1,43,670 for pilferage. So, Lordship, I am the regular user of the West Bengal
On that
electricity.
the electricity is being provided unauthorized to
Yes.
supply your premises for domestic purpose.
Yes, Lordship.
Yes, against you in the FIR.
Yes, Lordship.
Pilferage.
And Lordship, the bill raised against me 1,43,000. I am the regular user of the my customer ID is also there. I annex all the documents. Lordship, I am ready to pay the amount, but before facing the trial, I am the connection is
Subject to outcome of the criminal case,
yes,
you pay the amount. Once we pay
Lordship,
the amount, along
Lord,
with the
sudden amount I will pay. Lordship, sudden amount I will pay. Definitely, Lordship. Kindly, I have a 6 year petitioner have a 6 months old baby, and the electricity connection was disconnected.
What is the total amount?
1,43,000.
43,000. So you deposit the 70,000, 1,70,000 you deposit, and 70,000 within 10 days. And once they receive the
Lordship, 70,000. I will deposit.
I will dismiss. Then you go to the appeal.
Lordship, kindly in appeal, I have also paid the full amount. Lordship, kindly consider, Lordship, restore my electricity, and I will pay the 50%. Yes, Lordship, 50% I will pay, and 50% after.
By tomorrow, they will restore, and
Lordship, not by tomorrow. In the 1 week time, please provide me 1 week time, Lordship. 50% I will pay. Kindly restore my electricity after the completion of this, Lordship.
I am passing an order disposing of. You pay the 50%. Once you pay the 50%, they will restore the connection along with the reconnection charges. And the remaining 50% will be paid within 10 days from the payment of the first.
Lordship, not 10 days, Lordship. Kindly consider, Lordship.
If you want, are you disposing of, or let it
No, Lordship. I want.
Vacation.
No, Lordship. Kindly dispose it.
The petitioner has filed the present application, being agreed and satisfied with the.
Then Lordship, Lordship, kindly.
There is an appeal provision. While he may file an appeal, it will maybe there is a chance of reducing that amount.
They're not taking the. That's why I'm telling. She's not taking the benefit of that.
Well, 50% she will deposit, and if they
that I will not. If you want to withdraw, go to the appeal, reduce. The court will not give the such. The court is not so liberal that. It is your choice. Before this court, you have to pay the total amount. If you want to go to the appeal, I am allowing you to
send it to the appellate authority.
Are you withdrawing this?
Yes, Lordship.
The counsel for the petition press for withdrawal of the application with the liberty to file the appropriate appeals before the appropriate authority. Accordingly, WP number so and so is dismissed as withdrawn. Liberty to file the appeal before the appropriate authority. Yes, next.
My lord, do not take me. I miss.
Give the name. Next.
Yes, my lord, I appear for the writ petition. My lord,
Yes,
my lord, the lookout circular has been given to us. My lordship sees the circular read with the office memorandum of 22nd February 2021. My lord, I am on what fell from your lordship yesterday that the lookout circular, my lord, expires by efflux of time, and it is on the originating agency, my lord, to take steps under the memorandum of February 2021 to keep it reviewed. Now, if lordship sees, my lord, the circular, and lordship it kindly comes towards the bottom at the last page.
अरे कल सर्कुलर दिया कहाँ रखा?
My lord, I have got a copy of the circular if my lord so deems fit and proper. My lord, I have got it. You are talking about 20?
No, circular. This is the office memorandum.
Oh, your LOC?
Yes. दिया था जरस करके कहाँ है?
Lookout circular.
My lord, I am handing over one copy. LOC की copy दे दो. My lord, may have.
Yes.
Yes, lordship will kindly comes, my lord. Towards the last page.
Just a minute, Mr. Yes, Mr. Trivedi, you have taken instruction under which provision?
My lord will kindly see. My lord, first what has fallen from my lord?
Yes.
My lord was on 4 of the LOC.
4 LOC, yes.
My lord, here it is saying, my lord, they have carved out a particular proviso, all the LOCs other than those specifically mentioned in para 6J of the consolidated guidelines. Now, my lord will kindly come to the consolidated guidelines. Lordship has it, or should I supply a copy? My lord will bear me, my lord. This one, no? Lordship. Lordship, I apologize, not stitched, my lord. निकालते हो हम लोग की कॉपी कहाँ गई इधर होगी इसमें देखो बेटा my lord will kindly bear me I'm just getting my हाँ my lord I've got it My lord will kindly come to J.
Yes.
Lordship will kindly allow me to place it. It says the LOC opened shall remain in force until and unless a deletion request is received by BOI, Bureau of Investigation, from the originator itself. No LOC shall be deleted automatically. So, the circular says that no LOC will be deleted automatically, and in this particular LOC, there had it has this particular proviso has been carved out that all the LOCs which have been issued under para 6J.
Yes.
So our LOC was under 6J. Now, my lord, why it was under 6J, my lord? Iski aur ek copy de. My lord will kindly see our circular which has been given to us by the Ministry of Home Affairs.
May I get a copy of this circular?
My lord, here it specifically says that this is an LOC which is under 2J, which has been carved out. So, my lord will kindly, may I be allowed to read? The LOC opened within inverted commas. The LOC opened shall remain in force until and unless a deletion request is received by Bureau of Investigation from the originator itself. No LOC shall be deleted automatically. Originating agency must keep reviewing the LOC opened in its behalf or quarterly and annually on an annual basis and submit the proposals to delete the LOC. So, my lord, as far as this is concerned, 4 is concerned, my lord, that it is a generic relevant information and instruction which carves out LOCs which have been issued under 6J. My LOC has been issued under 6J, which cannot be deleted until unless there is a specific instruction which has been now substantiated by this circular. So, my lord, as far as that question is concerned, reviewing we have done. So, the LOC is there, live and kicking. So, my lord, the first question, my lord, what had fallen from my lord, I have humbly answered that.
Okay.
Now, my lord, the second cogent point, which is actually their point. This particular point came when my lord inspected the LOC. Now, my lord, the second cogent point, my lord, that they should receive the LOC, it's an income. Now, my lord, that has been challenged by us before the Honorable Supreme Court. Supreme Court has stayed that portion of Punjab and Haryana High Court's order, which says that it is mandatory to give LOC if you have issued one or initiated one. My lord, I will rely on that. Now, my lord, what point before Lordship for contention is that whether we are well within our rights to issue an LOC, whether we have cogent reasons for that, or it is in violation of Article 21, as in Menka Gandhi's case and followed by various. Now, my lord, let them amplify their argument on that, and whatever little defense I have, though substantial, I shall put it.
Yes, what is the prayer?
Yes, not for quashing of the lookout circular.
It is to be decided.
Yes, but in the if Lordship sees,
What interim order you prayed for?
I should be allowed to travel.
Several allegations.
Because I'll demonstrate that perhaps the lookout circular does not meet the tests laid down in
But the submission made by the authority that the investigation is completed, charge sheet is filed, so the
charge sheet not.
investigation is completed. So that
My lord, we have, my lord, I as my lord's officer, my lord, I will not say anything from the bar what instructions mine is, my lord. This is a particular, my lord, just I am taking 1 minute of my lord to just so that this cannot come against me that I have made submission from the bar, which is not correct. My lord, this under 212, my lord knows it very well, my lord. I need not repeat it, that this is neither an offense under the BNS or. Now, my lord, we received an intimation from the Ministry of Corporate Affairs, subject to which we start an investigation. The LOC, as my lords may see, we have initiated the LOC and what at page. My lord will kindly come to clause 4 at page 2 of the LOC, my lord. Roman 4. Reasons for opening the LOC. My lord has got it. Investigation under progress. Then we say FIR, we say MCA order. So, my lord, this is a case where now, my lord, what we have, our investigation is complete. We have given it to the MCA. Whatever incriminating materials are there. Now, my lord, Ministry of Corporate Affairs is still to give us an intimation, and then after that, the next process will follow.
the Ministry of Corporate Affairs is the party here?
No.
My lord, Ministry of Corporate Affairs, I suppose, my lord.
Not a party, not a party.
No, my lord, this is not a party. My lord, Bureau of Immigration is, my lord. Now, my lord, So, my lord, this is the factual matrix of the case as it stands today. Now, my lord, as far as our allegation is concerned, we are saying that it has been issued under clause L. That is our defense. Now, my lord, clause L is there, and if the writ petition is not being decided on merits at this stage, otherwise we should be given a chance to file our affidavit in opposition and reply, and then it will be decided on merit whether we have our invocation of this LOC under the guidelines L, that is exceptional cases, stands the test of Article 21 or not. Because, my lord, will kindly see our the guidelines of 2021 office memorandum. My lord, if my lord kindly comes to L.
Yes, I am there only.
Lordship. Now, lordship, we have initiated this LOC on L, saying that, my lord, will allow me to read clause B, lordship, third line, clause B above. If it appears to such authority based on inputs received that the departure of such person is detrimental to the sovereignty or security or integrity of India, or that the same is detrimental to the bilateral relations with the country or to the strategic and economic interest of India. This is what we are on, my lord. To the strategic and economic interest of India, or if such person is allowed to leave, he may potentially indulge in act of terrorism, my lord, terrorism offense. And then, my lord, I come to a last but two lines, the last penultimate line, in the larger public interest at the given point of time. So, my lord, our salvation lies in this exceptional clause, which says for strategic and economic interest of India, one, and the penultimate line of that particular clause, in the larger public interest and in a given point of time. Now, my lord, we have stated here that there has been total evasion, and there we have reasons while investigating that he has said that he has his account has not been declared as fraud. Now, my lord, what he has annexed, I may place it before my lord, because that there is a consortium of 5 banks. 2 have said that maybe it is not a fraud, but others have shown it a red flag. It has said it's a red flagged account. Those things. So, my lord, it is not in toto in his favor. One. Secondly, lordship, what we are trying to impress very humbly, that the reason which has been given by him at page 149 of the petition that he is wanting to go abroad, page 149, Miller, annexure P6.
Yes.
The reason which he had given at that point of time, lordship will kindly see the 3rd paragraph of that particular letter. If I'm not mistaken, it's January 21, 2025, my lord.
149.
149, lordship, annexure P6.
Yes.
P6, lordship has got. My lord will kindly allow me to read the 3rd paragraph where he gives a sum and substance of his reason. However, I am pressing personal and professional commitment that require me to travel abroad. These include the purchase and sale of certain plants and machineries in Dubai and facilitating further educational arrangement of my son, who recently completed his BBA in King's College, London. For his purposes, I am scheduled to travel with my family to Paris, Italy, and Dubai from 22/12/2024 and 5/1/2025, declaring departing from New Delhi. Now, my lord, this is partially for travel, for business purpose, for selling off of some of his. We have said that there is flight risk. One.
There is
flight risk. Because investigation is going on. Now, it cannot be proved to the hilt by them. They will say there is no flight risk. I am saying there is flight risk. So, my lord, it will have certain small amount of inclination towards him because I am an investigating agency. If I am not given this liberty also, my lord, then it will be, we'll become toothless.
But how far? 2022. Now we are on 25.
My lord, what I am humbly submitting, my lord, what I am at this particular point of time, my lord, we have, as far as हमने MC को भेज दी ना अपनी report. My lord, we have sent it to the Ministry of Corporate Affairs. Now, my lord knows, with my lord's understanding of the entire subject better than me, my lord, that they will give it then whatever. But there are incriminating material. Now, my lord, we are at this stage. There was a CAN application that has become infructuous. And, my lord, and we have filed our initial report that we are well within our right to initiate this particular LOC. LOC on the face of it cannot be said that it is per se illegal. Now, my lord, whether it holds the test of Article 21 or the various judgments which are governing the field is a question which is to be decided after exchange of affidavits. So, my lord will give us a short date for affidavits. We'll exchange and let the matter come up for hearing.
My lord, my first submission is that the requisitioning authority is bound by the reason given in the lookout circular. They cannot improve their case from the bar. Kindly take the lookout circular, the pro forma which they had filled up. The reason has to be stated, my lord. I had shown your lordship in terms of why originating. Kindly see, my lord, kindly keep the guideline side by side. Kindly see clause I of the guideline. Yes. In cases where there is no cognizable offense under IPC and other penal laws, the LOC subject cannot be detained or arrested or prevented from leaving the country. Well, this is the rule. The originating agency can only request they be informed about the arrival, departure of the subject in cases. And my lord, H is saying recourse to LOC is to be taken in cognizable offense under IPC or other penal laws. Detail in column 4 in the enclosed pro forma regarding LOC must.
From here, which clause?
H, my lord, of the guideline.
Yes, yes, yes.
Recourse to LOC is to be taken in cognizable offense under IPC or other penal laws. The details in column 4 in the enclosed pro forma regarding reason for opening LOC must invariably be provided, without which the subject of an LOC will not be arrested or detained.
Correct.
So you cannot detain me, my lord, without. Now kindly see what is the reason. Clause 4.
Investigation under process.
Clause 4 is investigation under progress. Criminal case, brief of case to be, it's only a lodging of an FIR. Ministry of Corporate Affairs ordered has been only given the date and file given. As if, my lord, this is a criminal proceeding. Kindly see, my lord, in that handwritten.
Yes, yes, I've gone.
Ministry of Corporate Affairs order. Today, my lord, my learned friend makes out a case in exceptional circumstances. My lord, kindly before that, my lord, it's covered by now, my lord, judgments of this court. My lord, may I first deal with that? Lord, exceptional circumstances, what, my lord? Fraud, monetary quantum will not improve. My lord, the first judgment I cite is, my lord, prior in point of time, Vishamba Saran versus Bureau of Immigration.
The other citation to the. Thank you.
Yes.
My lord, this, because, my lord, my learned friend cited this in exceptional circumstances, my lord, on record, admitted position is all they have done is they are in the process of investigation. They have completed investigation. When they had issued the requisition, they were in the process of investigation. Even if I take subsequent facts, they have only filed a report, what I heard from him. None of it, Millard, I'll come to that. Now, let us deal with what does it mean. Millard, kindly come to para 50. What my learned friend argued today also, Millard, they cannot, it has to be quashed. By filing affidavit, they can't improve the case. Millard, the lookout circular is on record.
Yes.
The limited ground as it stands amended, as mentioned in the relevant office memorandum, are as follows. In exceptional cases, LOC can be issued even in such cases as would not be covered by the guidelines, where departure of a person from India may be declined at the request of authorities of the above referred OM if it appears based on inputs received that departure of such person is detrimental to the sovereignty or security or integrity of India. My lordship will not find this reason in the lookout circular pro forma 4, or same is detrimental to bilateral relation with any country or to strategic and or economic interest of India, or if such person is allowed to leave, he may potentially indulge in act of terrorism or offenses against state, or that such departure ought not to be permitted in larger public interest. None of the above criteria are satisfied in the present case. The mere quantum of the alleged default cannot be taken as a basis for extreme measure of restricting the personal liberty of the petitioner to travel inside or outside India. In the absence of any such ground, the LOC was ex facie vitiated. My lord, ex facie, what has been given to your lordship, my lord, this is vitiated. None of these grounds are there. In the event the authorities seek to resort to quantum of alleged default for restricting citizen departure, it is obvious that quantum is relative and the amount of 340 crores can be exorbitant or meager, depending merely on whims of the authorities or the perspective of the judge. As such, in absence of any stipulation in that regard, in the relevant office memorandum, no cut-off line can be drawn between an amount which is detrimental so and so. In the present case, para 53, respondent authorities have failed to justify rationally as to why the departure of petitioner from India would in any manner be detrimental to the sovereignty or security or integrity of India or to the bilateral relation with any country or to strategic or economic interest of India as a whole. The mere subsistence of an allegation of default, my lord, I read it as fraud, would not trigger the issuance of LOC at the drop of a hat. As such, the expression detrimental to economic interest ought not to be an excuse to restrain citizens of India from leaving the country without convincing ground being disclosed for such restraint. In the present case, there is no allegation that CBI has an arrest warrant against the petitioner and or the petitioner's personal participation in CBI inquiries of utmost necessary. That apart, so on. Well, here the investigation is complete. My learned friend did not say I have not cooperated or I have not been present. Now, kindly see what is section 212. He has to comply with. So now my learned friend is changing his case that it is not of any of the grounds, but it is an exceptional category case. But his LOC doesn't say that. And kindly see 212. And his report, kindly take up the report. My lord, his report is contrary to his submission. Kindly take the report which he has filed. Report? Yes. The report is dated. It is filed on 28 July 2025. An affidavit found by K. Nikhil. Yes. It kindly comes to in this report, kindly come to page 2. Para 5. Petitioner being promoter, president, CEO of ARSS infrastructure was the key person and so and so. It is to be noted, company has an outstanding claim of 3897 crores presently as filed by the secured creditors before NCLT. Further, in the investigation conducted by this office, his pivotal role with respect to manipulation of financial statement and diversion of siphoning of funds injuring the interest of company creditors and other stakeholders of the company has been identified. My lord, let us assume this is correct. Then also, my lord, it doesn't apply. I'll show 212. Then, my lord, para 6, very important. Petitioner was summoned for the statement recording before office on 21st. He appeared on 8th April. And therefore, he is appearing in his, it should be thereafter, own whims and fancies and trying to delay the investigation. My learned friend has submitted, investigation is complete. Then, my lord, kindly see, my lord, vague allegations, para 3. I am surprised, my lord, this sort of affidavit is filed. In the statement also, his behavior was evasive. And he tried to avoid questions by mentioning he will later submit. My lord, he has completed investigation. If there is a cognizable offense, they will report it to the government. Government will then direct them to file this. And my lord, para 7, it is pertinent to note petitioner was asked to appear on 14 July. He requested to appear on a different date, asked him to appear on 22nd. In the interest of his request was allowed. However, again, my lord, I have taken time. But first I have appeared, I have answered the questions. Now, my lord, most important, investigation is complete. That's what my learned friend has said. Then, my lord, he is saying I have not given proof of certain documents or I have disobeyed someone.
Exception. fire certificate আছে showing that there was an event of fire.
My lord, in the exception, I have disclosed, my lord, that fire had destroyed. I had shown a fire certificate. Kindly see. But my lord, even if lordship takes it on record, my lord, it is nice because today his investigation is complete. Page 27 of 54.
Yes.
Lord, I am submitting, even if these are taken to be correct, lordship need not see my exception also. Fire certificate is there. He may believe or disbelieve. We will fight it out there. Now, my lord, kindly turn over. Very important. Kindly see how they try to camouflage. Para 10, it is stated that an investigation was carried out by CBI and ED on a wholly owned subsidiary of ARSS and has subsequently been charged by both CBI, so and so. Not my company, my subsidiary, that too by CBI. CBI has not given any LOC.
This has been quashed.
And this has also been quashed.
We have annexed the order.
And we have annexed that order. Kindly come to page 29 of 54.
Of the report.
Yes, my lord, of my exception. And it is to their knowledge.
13 February judgment.
Because this happened in 13 February and this is in July. I am surprised, my lord, this sort of affidavit is being filed.
Yes.
Well, at page 29, it's a order passed by the High Court of Orissa at Cuttack, my lord. Date of judgment is 13 February. Well, kindly straight away come to the operative part. It's a longish judgment. Well, firstly, it's of a subsidiary company, but be that as it may. Page 56, lordship. Sorry, page. Yes, page 53. Para 25. Accordingly, in light of following judgments of the Honorable Supreme Court in BB Agarwal, so and so, along with so and so, the charge sheet and supplementary charge sheet and proceedings consequent therefore are hereby stand quashed for the petitioners. And now lordship will see who the petitioners are. ARSS, that is, my lord, the subsidiary company. So this is quashed. Then, my lord, para 11, and this is telltale. It is to be noted, investigation is ordered by Ministry of Affairs to SFIO under 212 A and C. So they themselves say that beyond C, nothing has happened. 212 C of the Companies Act is with respect to cases which involves public interest. Since present case involves the interest of public at large and involves huge outstanding amount, therefore lookout circular was issued. My lord, already, my lord, all high courts have taken the point that money demand, 1 rupee, 100 rupee or 1000 crores is not a ground per se to issue a lookout circular if you do not comply with that. Matter primarily appears to be fraud, which is charged under 447, which is a cognizable offense. Well, at all conjecture. And now kindly see 212, the last. 212 of the Companies Act. Companies Act. Your lordship has the Companies Act. Now, my lordship will find 212 as, if I am not wrong, my lord, around 18 subsections. I am sorry, 17 subsections.
Yes.
And my lord, 212 is nothing but, my lord, SFIO is just another investigating agency. It has no special attributes or quality. Without prejudice to the provisions of section 210, where the central government is of the, may I just show 210 first? What is SFIO? 210. Where central government is of the opinion, it is necessary to investigate into affairs of a company, either on the receipt of the registrar or inspector or intimation of special resolution passed by the company, or it may order an investigation. Where an order is passed before a court or the tribunal in any proceeding before it, that affairs of a company, central government shall order an investigation. Now, my lord, kindly come back to 212. Well, 212.1, they are saying, my lord, A and C. That is, either there has been a report of the registrar or in public interest. Very well, you are investigating. But under what authority you are issuing an LOC? Then, well, subsection 2, where any case has been assigned by the central government to SFIO for investigation in this act, no other investigating agency shall operate. So, my lord, even assuming CBI, ED and all that, my lord, so no other agency can investigate this. So, my lord, reference to CBI, it's another thing, it has been quashed. So, they are the only person. Now, kindly see. 3, where investigation into the company has been assigned to serious fraud investigation, it shall conduct the investigation in the manner and follow the procedure provided in this chapter and submit the report to the government within such period as may be specified in the order. Now, we do not know whether they have done it within the period or after that. Let us assume, I take my learned friends, that they have submitted it. What transpires in that? Now, kindly see. Subsection 4, investigating officers, we are not concerned. Subsection 5, the company, its officers and employees who are or have been in employment shall be responsible to provide all information, documents and assistance as he may require for conduct of investigation. Then, my lord, subsection 6 is, notwithstanding anything contained in Code of Criminal Procedure of this Act shall be cognizable, and no person accused of any offence under those sections shall be released on bail. Malad, this is covered under 447. I'll come to that. Then, my lord, kindly comes to straight away. This is, my lord, for the purpose of summoning, my lord, the person during course of investigation. Today it is not required because my learned friend says it's over. Kindly straight away come to subsection 11.
Yes.
The central government, if so directs, the serious fraud investigation shall submit an interim report to the central government. I do not know whether interim report or final report, but be that as it may. Then, my lord, subsection 12. This is where we are. On completion of investigation, the Serious Fraud Investigation Office shall submit the investigation report to central government. Notwithstanding anything contained in this act or law for the time being, a copy of the investigation report may be obtained by any person concerned by making an application in this regard to the court. So, my lord, if they have submitted that, my lord, I have they have to intimate me that they have submitted it. I will get a copy of the investigation by making application. Then 14, on receipt of investigation report, central government may, my lord, kindly see, may, after examination of report and after taking legal advice, direct SFIO to initiate prosecution. This stage has not yet come. And, my lord, lock, stock, barrel, you have detained me for the last 5 years or 4 years. But only on the ground you are carrying on investigation. If it directs them, then, my lord, they will initiate. My lord, if I appear, I don't appear, cognizable offense or not, whether, my lord, flight risk or broad submissions are being made. Absolute abuse of power. Nobody has a clue of the powers, my lord, just being blurted out that I am at flight risk. This is the 14th stage has not yet come. And SFIO, it's being tom-tommed as if something as serious has happened. And quantum, my lord, there are 2 judgments of this court.
Yes.
My lord, the other judgment which I am relying is also Vishamba Saran, my lord. Kindly have a look. That exceptional circumstances, kindly have a look. That has also been interpreted.
কোন judgment দাদা?
আরেকটা ওই criminal circle ইয়েতে। Will it kindly see para 42 first? This court has already observed earlier that the expression economic interest cannot be read in isolation, but must be read into the context in which it has been used in the policy of 2010 as amended. Well, the parent circular is of 2010 and 2021 is the amended one. It cannot be given a narrow interpretation to mean and include the conduct of business between a bank and a defaulter. Well, here I have committed fraud of 300 crores. In the absence of an input that such borrower was likely to flee India and such departure would disrupt or adversely affect the economy of the country or jeopardize the bilateral business relationship or strategic relationship of India with other countries, such request could not be made. Subparagraph J of paragraph 8 had to be satisfied. The consolidated guidelines for issuance of LOC in respect of Indian citizens and foreigners found its final expression in the office memorandum dated 22nd February 2021. The guidelines of 2010, which were modified in 2018, were reviewed. Paragraph 6, subparagraph H to L provide the general circumstances under which opening of LOC could be requested by the originating agency, which include the chairman and managing director of public sector bank. 43. For convenience, subparagraph H, I, J are quoted below. Then, my lord, para 44 quotes subparagraph L, my lord, which my learned friend relies. Then, my lord, kindly come to para 45. The bank had to establish that the departure of the petitioner on the basis of intelligence report would be detrimental to the sovereignty, security, and integrity of India, detrimental to the bilateral relation of India with any other country, or detrimental to the economic interest of India. Although Clause D in the Office Memorandum of October 4, 2018 provided that those persons who were fraudsters or had taken loan willfully defaulted in payment of the same or laundered money and then tried to escape to a foreign jurisdiction should be included in the category of subject whose departure would be harmful to the economic interest of India. The policy of 2021 did not make a separate category under the exception clause for such person who were either fraudsters or willful defaulter or had laundered money and were trying to escape. Subparagraph L of paragraph 6 of the policy of 2021 is a verbatim reproduction of subparagraph J of paragraph 8 of amended policy of 2010. In the opinion of the court, the persons who had taken loan from public sector banks and had laundered money and whose actions had caused disruption to the economic stability, shares and stock market or had affected the current economic growth of the country would come within the exception clause. This court finds that the lead bank of the consortium has already requested for issuance of LEC against the petitioner and others. PNB also had highest exposure. Miller, that was, this is particular to that. Now, Miller, kindly come to all the banks, Miller, they do it because they say economic interest, because 300 crores, 1000 crores and all these figures. Well, at para 59 straight away, Lordship comes to the finding. Yes. In my opinion, personal liberty and fundamental right of movement guaranteed by the Constitution cannot be curtailed at the behest of BOB when the condition precedent for making such request of opening of an LOC did not exist in the case. The affidavit in opposition does not disclose that managing director had applied its mind or had received information or input from any investigation or intelligence agency to come to a conclusion that petitioner was trying to flee from India in order to evade legal consequences. In fact, my lord, the investigating authority has said that investigation is going on. He has said, I have appeared twice and his only grievance is I have not given all the documents, but investigation is complete. Yes. Then, my lord, willful default is pending under the bank has been non-payment of loan and dues of the bank cannot be equated to an act of destabilizing or affecting the economic interest of India. The freedom of movement of a citizen of India is a valuable right and cannot be infringed except by imposing reasonable restriction. Court does not find any reasonableness in the action of BOB. The lead bank is so and so. Well, already Lordship has seen in the guideline, all they can say is, I can understand. You are asking me, you inform the SFIO. That too when the investigation was going on. that when you are leaving the country, when you are leaving, when you are coming back, you can inform and go. This much they can do. Beyond that, they cannot. And now the investigations have been complete. Today, my lord, if today the central government has two options, it may direct prosecution, it may not. Even if it directs prosecution, then also, my lord, they would have to show that I am avoiding summons, I have not attended, then all these things come. I have cooperated.
Yes.
So, my lord, irrespective of that, my lord, on the face of it, now that is why, my lord, they put it under sealed cover and all that, my lord, they don't want it to be. Everywhere this is happening. On a, my lord, slipshod, my lord, apprehension, my lord, they are lock, stock, barrel. This is because, my lord, perhaps post Vijay Mallya, my lord, nobody wants to take any risk that this can happen. I can understand that. Anyway, everywhere, my lord, because, my lord, since I have been doing these matters, everywhere, Vijay Mallya and Chosky, as if, my lord, all over the country. In fact, if Bombay High Court had noted in division benches, noted that you just can't put all apples in one basket and just classify them merely because, my lord, monies are due.
Yes. Yes.
My lord, visa was more than that. It was 5,000 crores. And, my lord, the judgment is that the quantum does not determine. Yes. My lord, may I take
Befittingly, I will answer to each and every question. To my understanding and to the satisfaction of my lord, maybe not to the satisfaction of my lord.
Can I take my lord's leave?
My lord, I'll be hearing the writ petition holistically today. Then, my lord, I will, because that is the puro writ petition ta bole pehle to dada.
They have already argued.
I have already argued. I have no other point.
My lord, because when I will open my cards, my lord, they will say that all right, we'll go for affidavits. Otherwise, I'll not waste.
But this can't be. He has already, the report is in form of an affidavit.
I'm saying
File the
is,
report and you file the LOC.
I am,
And now,
my lord, I am putting him on a caveat. He should not come back that he had not argued the writ petition. I'm putting him on caveat.
Very
I'm not
well,
on caveat.
I am willing to take that risk.
Yes,
my
that's
lord.
what
He
I'm
need
saying.
not
That's
threaten
what
me.
I'm saying, Millard. I'm
If
saying
he says
I
anything
am not the
which
person
is
who
not
will
on record, that will be disregarded by the
not. My lord, can I, being my lord's officer and junior to my lord's senior friend, right from college, I will not do that. I will not do that. I will with all.
It is not a special privilege. It is not a special privilege. Personal equation.
That is what I've learned from him. That is what I'm trying to say.
He should do it lock, stock, and barrel because he is responsible. I have full confidence in him.
Now, Millard,
may I have my final?
Now, Millard, the points which have been taken.
How much time will it take? It will
Ballot, we have to finish it today. Otherwise, it will go after vacation. So, Ballot, because Millard, whatever points I will just go
behind you. There are so many.
Millard, I apologize, Millard. Therefore, I wanted this matter to go on affidavits. But since my lord has already, but Millard, I have to answer threadbare whatever he has said point wise. Otherwise, and also the judgments. And in response to those judgments, I will show two judgments because he has cited two judgments which are of the honorable single benches and where LOC has been issued by banks. Here LOC has been issued by SFIU on a different footing. Secondly, I am strengthened by two judgments, one of the honorable division bench of this honorable court.
Okay, okay. Then you
and then Millard,
come after vacation. I will hear you.
If it can be tomorrow, because I am
tomorrow I am in
from
personal
30, the lookout circular is of November. Now, my lord, investigation going on for 4 to 5 years. My lord, first time, my lord, I am detained.
Matter of 1 week, I will take on 5th or 6th.
Very well, then lordship keeps it, my lord.
5th or
and my lord, I am also giving them the
list.
judgments which I am going to cite here and now, so they can be
Give the
prepared.
judgment.
Here and now, my lord, I will give.
Because the other matters is there.
Since your lordship has heard it substantially, my lord, if lordship can kindly give us some precedence on the return.
Correct, I will take.
Grateful.
ए देखो सेकंड बहुत सेकंड में देखो कि खाली है सेकंड में देखो क्या टाइम खाली है
फिफ्थ इफ इट मे बी
या फिफ्थ या सिक्स्थ में देखो क्या टाइम खाली है सिक्स में नाइन्थ में खाली है कितना बजे
My lord, second will be a problem. My lord will kindly keep it.
फिफ्थ और सिक्स्थ
12 बजे का देखो 12 कौन सा खाली है
12 बजे
My lord, second, my lord, we both will be in difficulty.
फिफ्थ खाली है 12 बजे फिफ्थ सिक्स खाली है 12 बजे खाली है
fifth at 12
noon.
I'm grateful, my lord.
The learned counsel for the petitioner has concluded his argument. Counsel for the respondent has argued the matter at length, but due to paucity of time, hearing could not be completed. Accordingly, John. Let the matter appear on 5th of January 2026 at 12.
Well, taking this opportunity of wishing my lord a very happy and prosperous English New Year, because I may not appear before my lord tomorrow, Milan. In advance, happy English New Year, Milan.
All of you.
He is grateful.
Lordship, in this matter, I am appearing on behalf of the petitioner. At the outset, I beg to draw the kind attention of this honorable court to kindly have a look on the order dated 12th August 2025, wherein the Honorable High Court directed the respondent authorities to consider the prayer. Order dated 12th August 2025. And the order was specific that, and this matter was,
What is your prayer?
my prayer is that, Lordship, I am in incarceration for 26 years. So I should be released forthwith in terms of the order passed by
Under which section you have been convicted?
432, read with section
Where is the conviction?
433A.
Where is the conviction order?
Order is annexed here with, Lordship.
Where is the order of conviction?
Yes, Lordship, order is annexed here with, after page number 13, page 14 and onwards. Page 14 and onwards.
Where is the operative portion, sir? Where is the conviction?
Operative part in the last page. Last page of the order. That is page number 53. 52, 53. Death reference.
Shall suffer rigorous imprisonment for life and shall also pay 5,000 each in default to suffer rigorous imprisonment for 2 years. And for the offence 302, we maintain the sentence imposed against the appellant under section 201 and 2034 of the IPC. Yes, this is the order of. Where is the order of the sessions judge?
Order of the session judge I have not annexed here with.
Then,
as because order of the session judge is not required for premature release.
Death reference. It was a death reference.
Death reference.
So that reference has been commuted to the life.
Life.
So life has been when the original conviction was made.
Original conviction was made, Lordship.
17th February 2007.
2007. Okay. So now 20. How many years?
22 years, 6 months, 12 days.
Yes.
I have annexed the detention certificate at page number 54, annexure P2.
54.
Lordship.
Correct. Detention slip. 20 years, 6 months, 12 days.
On as per 26/4/2024. As per 26/4/2024.
Correct.
Now we are in 25.
Correct.
So Lordship, the respondent authorities also.
Yes, what is on instruction?
Lordship, my Justice Ghosh directed us to a review board to consider the matter. The matter was placed before the review board, and a review board has not recommended his name and given certain reasons why he has.
Where is the order? Where is the order? The review board order.
That is the Lordship, last paragraph, Lordship. Clause 3, serial number 1.
Give me a copy.
Just a minute. Uttam Das is the petitioner.
Yes. Serving the life imprisonment, so, though the Supreme Court correction recommended is premature.
एक कॉपी दीजिए. देखो तो क्या है बाबू. Last operative department.
Yes.
Lordship.
What can be done?
Lordship, I have not gone through this.
Take the report.
But 1 minute. Honorable Supreme Court in Joseph versus Estate of.
That's why I'm telling you. You take the report. Come after vacation.
Fix the date, Lordship.
The petitioner has filed the present application for premature release of the petitioner. He submitted the petition is in correctional home for the last more than 22 years. 22 years. Learned counsel appearing for the state has handed over the report of the review committee wherein premature release of the petitioner has not been recommended. The copy of the report is served to the learned counsel appearing for the petitioner. Counsel for the petitioner prays for time to take look into the report. Let the matter appear on 15th of January 2026 under the same heading. Yes.
Lordship, obliged.
Next.
I petition, madam.
Yes.
The hearing comes up before your lordship. In view of an order passed by the Honorable Supreme Court, believe the Honorable Supreme Court, my lord, whereby, my lord, the order passed by the Honorable.
Prayer. What is the prayer?
Prayer is for my.
On the last occasion, your lordship was
reconnection. My lord, prayer is reconnection of electricity, which was disconnected according to us illegally and without following legal norms, and my lord, in a most high-handed attitude, whereby, my lord, the professional interest of the petitioner has been, my lord, totally curtailed. She is without electricity and cannot run her business. Now, my lord, on those facts, my lord, the initial writ petition was filed. My lord, that order was challenged before the division bench. The division bench passed an order in favor of the writ petitioner. Thereafter, the matter went up to the Honorable Supreme Court, where, my lord, the Honorable Supreme Court had, my lord, set aside, my lord, the order passed by the division bench as also by the Honorable Single Bench, and, my lord, remanded the entire matter.
Where is the Supreme Court order?
My lord, Supreme Court order, my lord, would appear from.
What is set aside the impingement?
My lord, we have filed an affidavit, my lord, in terms of the order of the Supreme.
31 of the edition.
Now it is to be heard on merit.
Yes.
It is to be heard on merits.
So,
And one thing, your lordship, on the
affidavit
on the last occasion, your lordship directed, I have sub copy. This is my additional affidavit.
My lord, we have filed a can. My lord, we have also filed a can, my lord. My lord, because when the writ petition was filed, my lord, the connection was live connection. But on dismissal of the writ petition, my lord, the electricity connection was disconnected, my lord. So we have filed an interim application, my lord, along with the writ petition for reconnection, my lord, upon hearing of the writ petition.
We have received this application in the last Friday, but we want to take an affidavit on this application, lordship. Kindly grant us that opportunity.
with regard to the writ petition, affidavit is complete.
With regard to writ petition, no affidavit has been made, but on that basis, the matter has been disposed of by this learned.
No, after the Supreme Court order,
They have no.
to file affidavit.
We have already filed the.
File this report.
Yes, sir.
Affidavit.
My additional, they have also.
To file reply.
My lord, will file a reply to this, and if they file a objection to my interim application, I want to file a reply to that also, my lord.
The petitioner has filed an application being Can 1 of 2025, praying for interim order for restoration of the electric connection. For restoration of
electric
connection. Counsel for the respondents prays for time to file affidavit in opposition. The respondents have filed affidavit in writ petition. In the writ petition, after serving the.
It's an additional document in pursuance to the direction.
File the additional affidavit of the documents on behalf of the respondent after serving the copy to the learned counsel for the petition. Let the same be kept with the records. Counsel for the petitioner prays for time to file reply. Consider the submission made by the counsel for the parties. The respondents are directed to file affidavit in opposition, if any, in connection with Can 1 of 2025 within a period of 1 week after winter vacation. Full stop. Affidavit in reply to the affidavit in opposition, as well as opposition of the affidavit in reply to the additional document filed by the respondents, as well as the affidavit in opposition, if any, to the Can application be filed by the petitioner within a week thereafter. List the matter on 21st of January 2026.
Extremely grateful.
Under the same writing.
Lordship want to.
Yes, next.
17 like appear on behalf of the respondent 1 and 2. My lord, I appear. 17. My lord, I appear on behalf of the writ petitioner.
Yes.
But I tell your lordship sees your lordship's last order, but I was not present that day. Lordship had directed the respondent authorities to produce the passport manual.
Correct.
Now, my lord, I have just now been favored with a soft copy. My lord, this is with regard the matter is I'll not take your lordship's time. Matter with regard to the issue.
You will argue or you will take?
But I'll see look into that and come back because this needs to be argued.
After vacation?
Yes.
Uh,
Well, may it appear subject to your lordship's pleasure 1 week after the vacation?
yes.
I'm deeply.
The counsel for the state submitted. He has brought the counsel for
Well, I'm the
Counsel
petitioner. For the petitioner.
No,
I am for the passport authority.
Brought the instructions and the manuals, no?
Yes.
Counsel for the
Passport authority.
passport authority submits that he has brought the instructions and manual in terms of the order dated 18/12/2025, and the same have also served to the counsel for the petitioner. Counsel for the petitioner requires some time to go through the same. According cases adjourned, let the matter appear on 15th January.
I'm deeply
under the same heading.
Lordship, sir, Lordship want to mention.
Yes, item 18. None appears on behalf of either of the parties. No accommodation is sought for. None appears on behalf of either of the. No accommodation is sought for. Let the matter appear in the combined monthly list of February 2026. Next. Call. See, being the senior, morning, hi, now nobody's appearing. Yes.
I heard your lordships and I refrained from making a prayer because when I saw my lord what the predicament.
See, no, nobody's appearing. The urgent matter is listed. None appear, same order. Next.
Lordship, on the previous occasion, the state was directed to produce, Lordship, why the marriage cannot be taken place under under Special Marriage Act for a foreigner, Lordship.
Yes, where is the authority? Nobody's here. That is the problem. Mr. Shayan Ganguly. Come after vacation.
Lordship, kindly
None
fixes
appears
a
on behalf-
date, Lordship.
Huh?
Kindly, Lordship, it fixes a date, Lordship.
None appears on behalf of the respondents. For the intersubjective cases adjourned, let the matter appear on 7th January under the same heading. Yes.
My lord, I was only, my lord, praying. Item 133, I know your lordship cannot take it up. Well, I was praying for leave to move the vacation bank. Extreme urgency, my lord. This is the doctor's choice FSSAI matter.
Yes.
My lord, your lordship had granted leave, but I know, my lord, your lordship can't take it. I am only praying for liberty to move the vacation.
Item number 31.
133.
133.
130.
133. Leave is granted to the petitioner. Yes. Item number 133. Leave is granted to the petitioner to mention before the vacation
I'm very
for
good.
earlier.
I'm very good.
Lordship, want to mention item number 30, Lordship, dispose the matter, Lordship. I heard, just got instruction from my client, he is ready to pay the amount.
Already.
Other side is here, Lordship. Other side is here. Kindly register the electricity, Lordship.
She wants to pay the entire amount, my lord, I cannot stand it.
Lordship,
I don't know where is that order.
item number 30, Lordship, kindly, Lordship. Lordship, kindly.
Who has taken? Saurav Niche.
Lordship, kindly.
My lord, if it is 2 PM, so that all the arrangement.
Item number 13 का 2 बजे फाइल रखो देखता.
My lord, before your lordship rises, my lord, my lord has been pleased to fix a matter, specially fixed matter. My lord has been pleased to fix a matter, specially fixed matter tomorrow, my lord. But the hospital has acceded after the writ petition was served to them. The hospital has acceded to our request and has released the patient, my lord. So, my lord, the urgency is not there, my lord. The other prayers are there. So, my lord's time is precious, my lord. So, my lord may not treat it as special fixed, my lord, because my lord's time is precious. My lord.
इनका क्या मैटर? What is your number?
My WPA 29608 of 2020.
960 उसको list मत करो कल. Not to list tomorrow.
My lord, as new motion, my lord may.
As new motion, let it be not in the urgent motion.
My lord, the Rohingya matter, my lord, had passed an order yesterday. It has not been uploaded.
Which
my
one?
lord. My lord, the Rohingya matter, my lord, curriculum 28472 of 2024. My
I
lord.
find all the orders.
No, my lord, the order has not been uploaded.
पता जाएगा. देखो. I already signed.
It has not been uploaded, so I am unable to communicate.
Okay, I will check.
My lord, may I mentioning for a, my lord, may I mentioning for a, my lord,
mentioning this matter 18 and 19, your lordships make it, well, urgent motion, my lord, your lordships make this matter, my lord, I am for the petitioner, your lordships make this matter, my lord, in the monthly list of, I am, my lord, very urgent, your lordship kindly make it not today. 18 and 19, only make it not to 18 and 19, urgent motion, only make it not today, your lordship kindly take the matter tomorrow, very urgent matter.
Any order, if it will reach, it will take, it will not reach, it will be tomorrow automatically.
My lord, your lordship kindly make it in the monthly list of February.
18, 19.
Yes, my lord.
18, 19. Yes, you are not appeared. Yes.
My lord, at that time, my lord.
Sorry, sir. Once the matter is called, you are not appeared. You persons are wasting my time for.
No, my lord. No, my lord.
Yes, call the.
What happens, my lord? My lord, kindly excuse me, my lord. I am in code number 3, my lord. My lord, I am in predicament, my lord. Kindly make it, my lord. Kindly make it not today, my lord.
My lord, only.
My lord, very urgent matter.
No mentioning. Yes, call the matter. No mentioning.
13.
Item number 13.
My lord,
Yes,
item
sir.
number 13, your lordship has already passed an order.
Item number
13.
13.
Yes,
Why
13.
13?
Lordship, before lunch, I mentioned that your lordship already passed the order. We draw
तुम दे दिया मेरे को, हम बोला रखो. मैंने बोला आपको. मैंने बोला, I told you to place the matter. Only I told that the writ petition be kept here. Without the order of the court, you are taking all these things. Take the decision. Yes.
Lordship, my client instructed me, so he will pay. Kindly restore the.
You will pay the total amount.
Lordship, by tomorrow 50% and after 10 days 50%. He will pay.
The petitioner has filed the present application, praying for a restoration of the electric connection and for setting aside the bill, the claim raised by the CSC,
No, WBSC DCL.
WBSC DCL for an amount of rupees 1,43,670. When the matter is called, London Council for the petitioner on instruction submitted, the petitioner is ready to deposit the amount of rupees 1,43,670 in two installment. The petitioner will pay the first installment of rupees, first installment being the 50% of the total amount by
tomorrow or day after tomorrow.
By 26th of December 2025, and the remaining amount shall be paid within 10 days from the payment of the first installment.
Lordship, kindly restore the.
It is full stop. If the petitioner pays the first installment of rupees, first installment, that is 50% of the total amount to the respondent authorities along with the reconnection charges, comma, immediately the respondent number 4 shall restore the electric connection of the petitioner. Full stop. The petitioner is directed to pay the remaining 50%. Full stop. If the petitioner failed to pay the remaining 50% of the amount within 10 days, as undertaken by the petitioner, comma, the respondent number 4 is at liberty to disconnect the connection of the petitioner. WP is disposed.
Grateful.
Next.
My lord, I am appearing for response from each one.
Lordship, I am praying for not today. My lord, Mr. Rajdeep Mojumdar is leading me in this matter. He is on his legs in courtroom number 28, my lord. Kindly.
Let the matter place in the monthly list of February 2026.
Great. My appearance take to the.
Lord, I am appearing for the petition.
I am appearing for the state, my lord.
The petitioner.
For the petitioner.
Yes, I am for the application pending before the authorities, that should be considered by the
For what?
For consideration of
What is the request for consideration? What?
dispute regarding flat owners and the association regarding the outstanding dues of the maintenance charges. And is pending.
Where it is pending?
Pending before the competent authority.
Who is the competent authority?
Respond number 2, my lord.
To whom you have given the representation?
My lord, respond number 2, competent authority.
Correct. Who is the competent authority?
The
Respond number 2.
Yes, sir.
Yes. When you are given the representation?
First representation 8 February
8 February 2025.
Second 8 March 2020. 8 March last representation
8 February and 8 March.
Page 56, sorry, 65.
What is your prayer before the authority? Only requested to show us the way how we can collect the recurring and outstanding dues
Yes, sir. For the
and
maintenance.
maintenance. Who are you?
I'm the association, man.
You are the association. You are the association. And to whom you want to collect the rent? Other private respondents. They are the owner of the flat.
Owner of the-
They are not giving the subscription. What they are not giving?
No reason else.
No, what amount is required to be paid by the private respondents? 66.
Because of the amount.
66. Okay. Yes, who is for the authority?
Well, I'm from the state, I did not get the instruction till now. I'm appealing for the state. I did not get the instruction, madam.
I am dispose of the application. I am not passing any mandamus.
Yeah.
Direct and consider. The representation is to representation is pending along with the claim. Let he issue the notice and dispose of the claim of the petitioner in the present date application that the petitioner has made representation to the competent authority, that is the respondent number 2. With the request to direct the private respondents who are the owners of the flat in concern, who are the owners of the respective flats, are not paying the dues to the petitioner association. Full stop. This court find that on 8 February 2025 and 8th of March 2025, 8th of March,
It is March.
March 2025, the petitioner has made representation along with the list of the dues of the private respondents. But the respondent number 2 has not considered the said application, the representation of the petitioner. In view of the above, this court find that no purpose should be served by keeping the writ petition pending. According, the writ petition is disposed of, directing the respondent number 2 to consider the representation submitted by the petitioner dated 8 February 2025 and 8th of March 2025, after giving an opportunity of hearing all affected parties, including the petitioner, within a period of 6 weeks from the date of receipt of this order. WP is disposed of. Disposed of by passing a reason and approval. Next.
My lord, this is my application. On 25th September, your lordship directed to the state to file a report.
Correct.
So far, the constitution of the Mental Health Review Board. And my lord, I have.
Is that not?
It has not been constituted. My lord, the order has already been communicated to the principal secretary, Department of Health and Family Affairs, as well as my lord, I have Nilotpal Chatterjee, the Lanik Junior Government Advocate is representing the state here in my lord, and I have also informed him over telephone, my lord. But none of them are appearing right now today, my lord. That is the whole problem. To appraise before your lordship about the present scenario of the.
What can be done? Nobody is appearing. Mr. Chatterjee was appearing.
Let this matter come tomorrow. I shall also inform you.
Tomorrow it is difficult.
Milord, because, Milord, what is the problem, Milord? The child, which is,
I understand your anxiety and with regard to the matter, seriousness of the matter.
the mother, if mother can be, under the doctrine of parent-party, Milord, if the mother can be appointed guardian, Milord, he can be also, Milord.
That's correct, but there is a court.
Institute of Psychiatry is the, Milord, that is the, Milord, the excellence, Milord, that is the Academy of Excellence, so far the, Milord, the psychiatry. And, Milord, he may be referred to there, Milord. In earlier occasion, my Lord Justice Rajashekar Mantra also made to this, Milord.
That can be done. Let first, okay, not today. Inform the other side.
Yes, I shall inform.
Not today. Next. Yes.
This is that matter where the mother and son.
My lord, my senior is on leg. Kindly kept it short pass over, my lordship.
But I prepared
He's
a short
coming
note,
just.
my lord, of my son, a 2-page note. And there's another published today. My lord had directed that the fees of my client for appearance before my lord, the cost of my be reimbursed. But this is the mail that I had sent, and kindly see the reply. She was accompanied to Calcutta by her nephew, and the last page is the reply. Tickets by Jan Shatabdi and Vande Bharat and hotel stay. That is all that was sought. He was coming from Qatar. This is the stand of the sons.
Yes. Yes, you are paid.
My lord, kindly give it a short pass over. My senior is coming.
The problem.
I
Short
think
pass
the
over, my
objective to the Vande Bharat fare is not much, 12 months. 2 nights stay in Calcutta because she was answered.
What is the total bill?
13,000.
This is the total 13,000?
Yes, one of the second page of that one.
Yes.
13,008. And everything is included, the annex there. The onward and the return journey fare and the stay.
Yes. पैसा क्यों नहीं दे रहे हो आप?
मेरा नहीं है सर, मेरे को नहीं देना।
नहीं देगा?
बोलिए ना, मेरे को नहीं देना था, रिस्पोंडेंट 6 को देना था। मेरे को नहीं देना था।
My lord, my senior is know about the matter. I'm not instructed at all. Kindly keep it
This is why
pass over, my lord.
I
Kindly.
prepared the short note. I will not repeat publishments. That is there.
I'm
If
praying
my lord
for a
so
short
chooses,
pass
my
over,
lord
my lordship.
can keep it on 5th January or whenever my lord is commenced.
Learned counsel for the petitioner in WPA 10504 of 2025 has filed written notes of argument. Yes.
The stand regarding that reimbursement of the
expenses. We are paying 15,000. I am for the writ petitioner in item number 25.
There was a specific direction that the.
Madam, may I just? I am paying 15,000 presently. The charge she has given. We are ready and willing to pay the medical expenses 50%.
No, not that. That I will decide because it is not settled. Now I will decide the writ petition on merit. Correct. Now with regard to the mother came to this court and appeared, na, as per the soon she has raised the bill of 13,000. So what about that?
The answer is in the last page.
You have given the reply that you are only required to pay the 1% charges.
Well, I just received it right.
No, you who has given the reply? Who has given the, kindly see the last page. Who has given the reply? Your advocate has given the reply, Ramnendu. He has given the reply.
More than the amount, this one speaks.
13,000, nothing else.
My lord, this is, my lord, had it been settled, things would have been different.
This was
What can be done?
I am ready and willing to bear the expenses of the mother coming. If my lord, 2 other people wants to follow her.
Follow her. How can an 80-year-old lady be?
No, you could have been told on that day she could not come alone. The court could have been passed an order. This court has passed an order. That's why she is not able to appear. Then the court directed to appear through the virtual mode. But You came before this court along with
She was
your
here.
sister. How this can be burden to the petitioner, because one of the son is totally refusing to pay the amount. So how the total burden can be, because kindly see the order. This court, what the court has, the court has not passed an order. The court has passed an order, whatever the expenditure will.
That the
Yes.
train fare of the two, who accompany them will be deducted and the balance.
Yes, petition is ready to bear, to appear before this court in person. The private respondent being the son of the shall make necessary arrangement for bringing the mother before this court on the next page. So you came with your sisters, how can it say? You could have said,
So
now you can.
The hotel fare for 2 nights and the individual fare, her individual fare.
Correct, that can be.
Well, the individual fare, let them indicate what the individual
hotel stay, hotel
Well,
stay.
may I just what
Let me, this train ticket is to be divided into two.
3.
Correct. And a taxi and the, huh?
Nephew and niece, it will be divided by 3.
3. So it is divided into
And the
3.
hotel stay, 8,000 for 2 nights. That's all.
So
we will not beg for the food. And all that.
No, it's not about the question of
It
that.
has
It's
now
not
come
about
down
the
to that.
Let
It
him
has
not
come
put
down to
word
that.
into my mouth, beg and all those things.
It has come down
Well,
to
if
that.
he's entitled to something, 8,000 for 2 nights, let them produce.
It is annexed there.
Now, kindly Lordship will see. There is a extra occupancy charges, extra person charges. But I am ready and willing to bear the expenses for my mother.
Correct.
I am not ready and willing to bear the expenses from the others.
Correct. This may be divided into 3. Whatever the amount.
Room tariff is given, 2521.
But 3% has stayed.
2521 is the room
Where
tariff.
is that? Which page?
Well, this one. It's not page.
Yes.
2521. There'll be taxes.
এখানে আছে তো এখানে আছে
There'll be taxes on that.
Yes, 2521
for 1 night.
Correct. Extra person 235, room tariff so extra person so luggage charges. So 2521 of the hotel.
Into 2 for 2 nights.
Huh?
That is for 1 night. We stayed here for 2 nights. The train was at 6 o'clock.
Where is the hotel charges in your kindly come to the first page. Where is the hotel charges? 6,149.
Yes.
So you are with 2521
For 1 night, it will be for 2 nights.
into
Can
2.
you see the previous page?
Let them indicate what is the individual expense of the
So
month.
5,042.
Yes. And the train fare for 1 person.
Huh?
And the train fare for 1 individual.
Ticket fare.
Yes.
But you kindly appreciate it is their own admission.
So you do one thing, you again this will be the problem. So train ticket only the divided into 3.
And a train ticket, whatever is the amount, I think they have indicated in the chart, that is 3585. That if we divide it by 3.
No, first is 3585, then 7, last one 1980.
The return journey.
Return journey. So this may be divided into 3.
3.
Correct.
They have asked for hotel at the rate of 6149.
No, that is a 5042.
5042.
5042. 5042. Correct. And taxi, okay, she has to come to the court. Return hotel, okay, she has to go to the court. Lunch and dinner, leave aside all these things. So only the 5,000 here, and the ticket is to be divided into 3, and 5042 of the hotel charge.
Divided between the two sons.
Yes, you give the total, dividing that, and they will pay.
I will pay 50% of the. I cannot refuse to pay. I cannot be burdened with the other son. I cannot.
No. On the last orders, you are taken the.
I said, my lord, I have said on behalf of one of the son, my lord.
Correct.
I am burdened with all of the expenses, my lord. That even there is another son.
Kindly see the order dated 4th December. Petition is ready to bear the appear before this court, and the private respondent number 6 being the son of the petitioner shall make necessary arrangement.
If that is the order, whatever my lord passes an order, we are
The-
ready to bear. But lord, she will kindly also keep in mind the fact that she has also.
So you will file the written notes of argument.
Well, we'll argue the matter whenever lordship gives it after the vacation, my lord.
But the argument is over.
No, my lord, it was not.
Petitioner
Okay,
has
my lord, we have to argue, my lord, on the changed circumstances.
0504 of 2025 is filed the written notes of argument. Let the same be kept with the record. The petitioner also submitted the document showing the expenses made by the mother to appear before this court, which is to be paid by the respondent number 6. Respondent number 6 raised objects on the ground that the respondent number 6 has submitted before this court that he will bear the cost and other charges of appearing of the mother before this court, but the mother has raised the bill of 3 persons, which is to be settled. Accordingly, the petitioner submitted the hotel charges rupees. Accordingly, petitioner is directed to submit the revised bill to the respondent number 6 within a week, and on receipt of the said revised bill, the respondent number 6 shall pay the said amount to the mother. Police counsel for the petition in the other. What is the writ petition number? What is your writ petition number?
My lord, item number 25.
Writ petition
Next.
number 16316. 6th of 2025, prays for time to argue the matter. According case is adjourned, let the matter appear on 8th of January 2026 on the same heading. Next.
Obligement.
Yes.
His Lordship, I am appearing for the CSC.
Yes.
Occupier of the premises. He applied for new service connection. My lord, the CSC authority under his bill, I paid fee. Thereafter, steps has taken to install the meter. The private respondent was raised.
Yes.
Your Lordship, on the last occasion, Justice Kaushik Chandra directed to file a report. I am filing a report.
May I have a copy?
I'll give
Yes,
you a
give the
copy.
copy. Give the copy.
I'll give you a copy.
Concerning situation and shall be liable to provide exactly adherence to direction and good.
I'm dee do copy dee do.
Yes, your building is having a plan, municipal plan. Yes, they have raised the objection that there is no municipal plan.
Lordship, may kindly come to the second page. There is title suit pending and title appeal also
Title
pending.
suit nothing. Title suit is
And
nothing.
Lordship,
What is
may
the plan?
see the report of Bali municipality
Correct. That's what I'm telling. Where is which page?
and fourth page.
Let the copy of the report be given. I shall find the exception on the next. On the next day,
Bali report, Bali municipality has filed a report and the unsanctioned plan. Lordship, may kindly come to the third floor, fourth floor, fifth floor, sixth floor, not sanctioned. There was a sanction up to second floor.
What is your name? What is your name?
My lord, my name is Muhammad Safiullah Ansari.
Safiullah Ansari. So you have received the notice on 12th of August 2024. Yeah, okay, you saw the notice. Serve the report to the cops.
Yes, Lordship, I'll give the copy in the course of this day.
Copy.
Yes, I will give the
In terms of the order dated 10th of June 2025, the CSC, the London advocate appearing for the CSC has filed the report. After serving the copy to the London court for the petitioner, counsel for the petitioner wait for time to go through the report, and if necessary, he will file exception. Police, in view of the above, case is adjourned that the matter appear on 13th of January 2026 under the same heading. In the meantime, the petitioner intend to file the exception to the report. The same may be filed after serving the copy to the London.
I'm serving the copy here.
Respondent. Next.
Grateful, Lordship.
Completed my construction. Thereafter applied for new connection. My lord, kindly comes to page 73 for once. That is a provisional quotation raised by the distributing authority.
Yes.
Now, my lord, thereafter, after I paid, my demand draft is on the next page. I have paid the all necessary fees.
73 is the demand.
Provisional quotation.
Correct.
Thereafter,
84,179.
No, my lord. Next page, my lord, I have paid by my receipts.
Yes.
My lord. Thereafter, another quotation was raised, page 75 and 76. I have my receipt of payment.
Two quotations,
My lord,
two connections.
two connections. Thereafter, my lord, I was called by the Gram Panchayat. They give, after inspection, my lord, page 78, my lord, kindly sees, that is their revised diagram of the proposed connection to be installed. My lord will find at the top left, signature of the Pradhan, Shoma Das. My lord, got it, my lord?
Where? 78.
78. At the bottom left corner, my lord? My lord.
Yes.
My lord. Now, my lord, thereafter kindly comes to page number 20, page number 86. No, all this is completed in 2024. Now, 2025, I have been given a memo by the distributing authority. My lord, kindly sees the reason. With reference as above, you are hereby once again being requested to furnish suitable court order in view of the title suit case number such and such, which is pending before such and such, and status quo maintaining order has been passed on such and such, and informed by Abhishek Chatterjee, learned advocate, to enable this office for effecting subject mention electricity connection. Now, what had happened, my lord? I am the developer. Landowners filed a suit. There exists an order of status quo. Now, my lord, in the meantime, I've completed the building. Prior to that, now, my lord, I applied for the sanction. Applied for sanction plan that was given. I applied for the electricity. That was the only thing I needed to take care of. Now, I have done my part. I have given everything. My lord, this status quo order passed in a civil suit cannot take away my right to electricity. And my lord, what had happened? Why I mentioned this matter on urgency? Kindly see the next previous page, 85. The police officer have been informed. A complaint has been lodged against me before the concerned police station, citing reasons that I could not give electricity by the purchasers of the flat. Now, these are my summons substance. Now,
Yes.
they have filed a report.
On the last occasion, probably my learned friend was present. I have already had over the
Yes,
copy
yes.
of the report. If you lordship kindly peruse the order passed on the last occasion by this coordinate bench on 25th of September 2000, September 2025. Where my learned friend was directed to add the Gram Panchayat as a party. Probably that has been added, and the private respondent has been, because the problem is that we are not standing in the way of granting electricity. Your lordship know that the filing of any suit in a civil court there is no impediment in granting connection unless there is a specific order passed by the civil court. Now here we have received objection from the concerned local authority. We have got objections from the private respondent, physical as well as written objections. Now our hands are tied, and we have immediately intimated to my learned friend's client that this is the situation, precarious situation we are facing. And we have filed the report. If you lordship kindly peruse the report, that report will speak for itself.
Where is the report?
My report has been filed on 25. That is on 25th of September 2025.
Report dated 25th June.
Lordship got that report?
Yes, yes, yes.
Well, the entire report says, since due to pendency of a civil suit and a order of injunction.
And local authorities' objections.
Due to pendency, that is also.
That's all.
Yes.
I'll read on a judgment passed by this honorable court by Justice Bakchi, as his lordship then was, my lord. My lord kindly comes to internal page number, page 3, my lord. Para 4, my lord. Internal page 3, para 4. Now, the Act of 2003, it starts. Therefore. Right. Mere objection of an owner occupier to lay works on his land cannot.
Where from?
My lord, internal page 3, there's a paragraph 4. After that, it starts from the Act of 2003. Therefore.
Really permission.
তারপরে আছে দুটোই কভার করেছে my lord got it yes that is one aspect, and the civil suit aspect was taken care of by his lordship on the next page, third paragraph from the bottom, the other contention relating to pendency of civil suit.
Yes.
The other contention relating to pendency of the civil suit. My lord.
The petitioner has filed.
And praying for kind liberty to file an opposition regarding praying for
my turn.
Praying for kind liberty to file an opposition, lordship.
You file.
Well, I am for the private respondent, 6 to 10, Lordship.
Okay. The petitioner has filed the present writ application praying for a direction upon the respondent of respondent number 2 and 3 and 4. That is three and 4.
My lord, my prayers are at page 15.
3 and 4.
3 and 4 are, my lord.
2 and 3.
The Novogram Customer Care Center of the WBCTCL and the station manager of the Novogram Customer Care Center. They are the.
So kindly see your repetition. Who is the 3 and 4?
My lord, 3 and 4, my lord, will find at page.
For the Novogram Customer Care, West Bengal.
Novogram Customer Care Center.
And 4 is the
station manager of the customer. They are the implementing authority.
Consequently, the petition has filed the present respondent number 3 and 4. 4 for taking appropriate steps for providing for installation of the new electric connection in the subject property being Gulmohar Villa, laying and situated at Mauza, Pura Binda Bera JL number 26 and JL number 6, RS Dag number 334 and 335, LR Dag number 1079, LR Khatan number 1065 under the police station, Uttarpara district. Petitioner submit that the petitioner has applied for grant of electric connection, and accordingly, the authorities have issued the quotation. And as per the quotations, and as per the quotations, the petitioner has paid the amount. But in spite of the payment of the amount, the authorities have not provided the electric connection on the ground that there is an objection from the villagers.
Complaint.
Compliance of necessary.
The petitioner has received a communication from the WBSCDCL on 22nd of April 2025, wherein it is informed that the authority came to know with respect to the said property, a civil suit is pending, and in the said civil suit, there is an order of status quo passed by the learned civil court, and as such, the authorities are not in position to provide electric connection to the petitioner. In terms of the order passed by this court, the authorities have filed the report. In the report, it is mentioned that the authorities are ready and willing to provide the electric connection to the petitioner, but there is an objection from the villagers, and there is a civil suit pending before the appropriate court, wherein an order of status quo is being passed, due to which the authorities are not in position to provide electric connection to the petitioner. Learned Counsel appearing for the private respondents number
6 to 11.
6 to 11. Prays for time to file affidavit in opposition. Heard the Learned Counsel for the respective parties. Learned Counsel for the petitioner has relied upon the judgment in the case of SK Samsud Doha versus the West Bengal State Electricity Distribution Company Limited and others, reported in 2012 SCC Online Calcutta 4314, wherein the coordinate bench of this court has held that mere objection of the owner of the occupier to lay such works on his land cannot be reason for licensee to shift its statutory duty to supply electric energy, which are essential service and an ingredients of the fundamental rights to life and individual in modern day of society. They further submit that the coordinate bench of this court has further held that mere pendency of the civil suit and the order of status quo as to the nature and character of the suit property also does not stand in the way of the WBSCDCL to discharge its statutory duty and to provide electric connection to the petitioner, who is admittedly occupier of the property in question. Had the Learned Counsel for the respective parties peruse the materials on record and the judgment denied by the parties. The private respondents press for time to file affidavit in opposition. This court find that the the only objection, the WBSCDCL have not provided the electricity only on the basis of the objection raised by the private respondents on the ground that they have initiated a civil suit and there is an order of status quo. This court finds that the petitioner has applied for electric connection and on the application of on receipt of the application, the WBSCDCL has issued the quotation and the petitioner has already deposited the said amount. The WBSCDCL only has not provided the electricity connection due to the objection and the order of status quo passed by the learned civil court. Considering the above, this court find that this court find that it is settled law that mere objection of the owner, mere objection by the villagers, and mere obtaining an order of status quo with respect to the property will not prevent the WBSCDCL for providing electricity connection to the petitioner, as the electricity connection is the essential service which is required to a nominal which is essential service. Full stop. Considering the above, the WBSCDCL is directed to provide the electric connection to the petitioner within a period of
Subject to compliance
within a period of
4 weeks because the high tension.
within a period of 4 weeks from the date of compliance of all formalities by the petitioner.
My lord, I'm pressing for prayer B as well, my lord. My lord, kindly come. Police help, my lord.
It is further made clear that at the time of grant of electric connection by the WBSCDCL to the petitioner, if there is an objection from any corner, the concerned police officer
paying of requisite cost.
the concerned police the officer in charge of Uttarpara police station shall provide necessary police protection to the officials of the WBSCDCL for providing electric connection in the premises of the petitioner. Full stop. It is further made clear that if any charges is required to be paid for police protection, the same shall be borne by the petitioner. WPS census disclosure. Next.
I wish you a lot.
Thank you. Same to you.
But this is a well settled law. If it's civil suit and Opimonnu Mojumdar case, it is a daily division.
What can all are settled, but in spite of that, the public has to rush to the court.
I appear for the respondent number 1.
Yes.
By Honorable Justice they have participated in the auction and
What auction?
TW4 and TW5
Mm.
of Towering Court. Towering Court.
Where is the tender?
We have submitted the case located at
12.
Yes.
Mm.
And the contribution made at page number 82.
Ah.
Yes, and this is for TW5 and page number 19 is for TW4.
Mm.
Page number 9.
Yes.
Now, they have confirmed our option and take the confirmation letter. Here, the shading logic. Logic can see the chart below there. We need to submit the option amount within 5% of the amount within 7 days and rest of the amount within 30 days. My client has paid within 30 days within 7th March. But logic, the second payment. First payment was made on 31st January.
No, when the notice was 6th of February 2025, the notice was issued. So you have to pay by the 25% within 7 days. 7 days.
My client has paid 37.
Hmm.
I did.
Correct.
She has paid the interest within 7 months. That is 38. 38. That is within 7 months.
Hmm.
I paid the interest.
Hmm.
Because,
Hmm. What certificate? Sale certificate. Hmm.
Only for conversion by this report, they can convert that by the order of this.
Where is the order? They have to.
That's the part of communication.
Hmm.
That by the they can convert
Hmm.
that.
So whether other party was there, how many persons have participated in the set tender? How many parties have been participated in the set process? So if suppose you are not deposited within 7 days, the other party have been called and he has deposited the amount.
Respond number 1, my lord, appearing, he can say, my lord. What is that?
Respond number?
I am appearing on behalf of the respondent.
I'll tell you what happens here. I appear for respondent number 1. What happens here, my lord? This, my lord, knows, my lord, the Justice Talukdar committee is there, my lord, heading the one-man committee. Now, my lord, what happens? These are all cheat fund companies, my lord. All the properties are given for auction, my lord, through respondent number 1. Now, there is a principle set in the auction notice that they have set, the committee has set. Once the, if in case of any of the properties, be it X bidder or 10 bidders or 11 bidders, the first bidder, if fails, my lord, it is not given to the second bidder, if at all he is there. That's the policy of the notice. But in this particular case, there was no bidder. He was the only bidder. But there was a timeline which has been
Why you are
framed,
not
my lord.
accepting? Why you are not accepting? If there is no other bidder and this is only one, so why you are not accepting?
My lord, that scenario, no, in that scenario, kindly see paragraph number 8. It will make clear.
Paragraph
I
8
am not standing in the way. Kindly see
Paragraph 8
paragraph
of-
number 8, their submission. Paragraph 8 of the writ petition. Kindly seize once. The writ petition at page 5.
You are the committee. You can take a decision.
They
You
have to say,
He is
I am
not a
just
committee.
the auctioning authority.
He is not a committee.
Malad, I am not the authority. I am not standing in the way. I am ready to give the sale certificate. But it's them, Malad, appointed by the Honorable High Court, Malad. The committee has to say. Malad, I cannot stand in the way. I am not standing in the way.
who is in the committee?
Committee is not a party in this.
Yes, where committee is not a party. Where's the committee? Then
Millard, I am a company, Millard. I want to, Millard, sell out entire property to repay the loan to the investor, Millard. So, Millard, kindly, Millard, given liberty to add a party in the meantime, Millard, direct to the one-man committee in the meantime, sale certificate issued. In that case, Millard, property will be sold, Millard. In that case, Millard, the depositor can, Millard, receive the money.
Well, it is a fact, Malad, money is lying with us. It is a fact. There was a delay in the 25% tranche payment, but the 75% amount was paid in the exact date. So it is a fact. But the committee has to say, because there is a submission, the committee has asked the petitioner to approve.
Committee consisting of one-man committee.
Now headed by
One-man committee, my lord.
Subrata Talukdar.
Justice Subrata Talukdar, my lord.
But one problem is that the committee should take an initiative, but
Pursuant to the advertisement
sitting
in
will
the
try
daily
to overlook.
newspaper on 30th December 2024, the petitioner has participated in the e-auction process of the assets as advertised in the said paper of Tower Infotech Group of the companies of Tower 4.
Malad, TW4 and TW5, that's the grievance of the petition. And TW5.
And TW5. List of the respondent's authorities have informed the petitioner that the petitioner has become the successful bidder for the property TW5 for a total sum of rupees 33,71,123. And with regard to TW4, the total bid amount was 51,46,812. Full stop. As per the conditions Foolish. As per the conditions, the petitioner has to pay the 25% of the highest bid amount within 7 days from the receipt of the intimation, and the remaining amount is to be paid within 30 days of the auction. That is correct. Foolish. Counsel for the petitioner submit that the petitioner has deposited the 25% of the highest bid amount on 18th of February 2025, that is after the period of 5 days. After the period of 5 days, that is after the period of 5 days, though the petitioner had to pay the said amount by 13th of February 2025. Full stop. With respect to the other, that is also same. Fine. Full stop. Full stop. Counsel for the petitioner further submit that the remaining amount has paid within the period of 30 days of the auction. That is on 7th of March 2025. Full stop. And counsel for the petitioner submit that though there is a delay of 5 days for depositing the 25% of the highest bid amount, the committee has not accepted not issued the work order, sale certificate to the petitioner. According, the petitioner has filed the present writ application. The learned counsel appearing for the, you are appearing for the
Respondent number 1. Respondent number 1.
I am respondent number 2.
Respondents submits that it is only the committee to decide to condone the delay. To condone the delay of 5 days. If the committee will accept the same, the respondents will issue the sale certificate to the petitioner. Had the learned counsel for the respective parties peruse the materials on record. There is no dispute that the petitioner is the highest bidder with respect of the TW3 and TW4 and
TW5.
TW4 and TW5. The only dispute that the petitioner has not deposited the 21st payment of 25% of the bid amount within 7 days. But the petitioner has deposited the amount after the period of 7 days. After the period of 7 days, that is on 18th February 2025 instead of 13th of February 2025. It is further informed by the learned counsel for the respondent number 1. As per the terms and conditions of the tender document, there will be a no second highest bidder. Full stop. And if the first bidder is not coming forward, there is no provision for giving the tender to the second bidder. Accordingly, this court finds that there is a delay of 5 days for paying the amount, the first 25% of the amount, due to which the sale certificate has not been issued to the petitioner.
Lord, I am.
In view of
Lord, may I leave? Lord.
In view of the above, the committee. Correct. But the petitioner has paid the final amount within the period of 30 days. Considering the above, this court request the one-man committee to consider this request of the petitioner in sympathy way and to condone the delay and to issue the certificate of sale within a period of 2 weeks from the date of receipt of this order.
I'm grateful, Lordship.
Affidavit be kept with the record.
29. Is a divisional manager. Petitioner is a divisional manager of LIC.
Yes.
Petitioner is a divisional manager of LIC.
Divisional manager of LIC. Yes. What do you want now?
Development officer. Development officer.
Huh?
Development officer.
What? Where is the this your? No. Where is your order? 28 January 2025. Where is the order of impugn order?
Page 21.
Page 21.
Page 21.
Page 22. Page 22.
Disciplinary authority by virtue of power vested so. amended up to the date of censure and recovery of 1,90,102 as proportionate amount loss caused by the corporation, loss to the corporation. Yes. So what do you challenge this? Sir, you have challenged this order. Disciplinary proceeding was initiated.
This is the disciplinary proceedings order.
Only charge against him is that matter. His signature in the change of nomination form, but without any verification, that has been or charge has been imposed upon the petitioner. Even Mala stated in his order stated that the petitioner is not a beneficiary of the said thought.
Sir, you give the answer to my one by one. Whether the charge sheet has been initially so cause was issued to you. Initially, the so cause was issued to you. Yes. Have you given the reply to the so cause notice? Charge sheet was submitted. You have faced the disciplinary proceeding. This is the first appeal or this is the first order?
This is the first
disciplinary order. There is no appeal provision.
Yes, my lord. There is an appeal provision. My lord, kindly see right of appeal 40. Every employee shall have the right to appeal to the appellate authority specified in Schedule 1 against an order imposing upon him any of the penalties specified under Rule 39. An appeal against the order of suspension passed under 36 shall lie to the authority to which authority has made or deemed to have made the order of suspension is immediately subordinate. Notwithstanding anything contained in the rule, the subject to the provision of Life Insurance Corporation Act rules and rule, no appeal shall lie against an order made by the corporation under Rule 36 and 39. So, my lord, this was against.
The order was passed.
My lord, this order was passed
January
on 2024.
25. January 25.
Sorry, 25. The show
when you file the writ please, please.
Signature also not verified.
Please. You file the writ petition on when? May 2025. That also after the period of limitation. You have to file an appeal. Writ court cannot. And now this barred by limitation. Can you see the 41? No appeal under the chapter entertained unless the submitted period of 3 months from the date of so and so. Provided the authority may entertain the appeal exercise, if is satisfied. So you withdraw this, file an appeal, giving liberty to make an application for condoning.
It has been imposed on 1,90,000.
Ah.
Already on 1,26,000. Every month deducting from his salary.
Correct. This court is not having. Yes. What do you want to withdraw, or I will, can I pass an order on merit? You withdraw. I am giving a liberty to file an appeal. Once you appeal, you will get the appeal order set aside. Automatically, the amount will be reverted back to you.
In case if he succeeds.
The counsel for the petition submit that the order impugned dated 28 January 2025 passed by the disciplinary authority is an appealable order. Accordingly, he prays for withdrawal of the writ application with the liberty to file an appropriate appeal before the appropriate authority. In view of the submission made by the counsel for the petitioner, the writ petition is dismissed with the liberty dismissed as withdrawn with the liberty to take appropriate step for filing an appeal before the appropriate appellate authority. It is made clear that the petitioner will file an application for condoning the delay, the appellate authority shall consider the same in accordance with law.
I'm so grateful.
New connection.
Lordship, I am the added respondent, Lordship. I don't know whether.
I thought you have become the WBSCDCL.
No, Lordship. I am the added respondent, Lordship. I have not been served with the copy amended writ petition, Lordship. Whether. Yes, only writ petition has been served, Lordship. Writ petition has been served. It is not the amended. I have not been added.
Your name will be added.
Lordship.
What is your objection?
Lordship, primarily, Lordship, suppression is there, Lordship. Against the said building for which they have demanded the connection, Lordship.
Which was the authority?
Yes.
CSC you are appearing.
Lordship, for the building, there is one writ petition is pending before Justice Raja Bosu Choudhury against challenging the legal
Construction.
deviation of the said building, Lordship, from the sanction plan. That has not been heard out. No mention of the said writ petition in this writ petition, Lordship. In suppression of the fact, Lordship. And Lordship, I will pray for Lordship the KMC be added as a party in this writ petition, Lordship. As a
This is not official
added respondent 4 হবে 1 2 3 the report yes writ petition is pending lordship briefটা কোথায়
What in which property you want interim order in this electric connection? 3242. 3242 Vidyasagar.
Lordship, writ petition is pending against that. That has not been disclosed. I will pray for Lordship KMC be added as a party. Lordship.
But there is a report.
Lordship.
There is a report having the sanction plan.
Lord, sanction plan is there, Lordship, but from the sanction plan they have deviated and they have also raised the cantilever that has come over my roof, Lordship. Lordship, may I submit only once, Lordship? What has happened? They have not left the statutory gap of 4 feet, Lordship. That no, the petitioner in the making of the building that has damaged my building, Lordship. And in the monsoon, water is pouring in, Lordship. Against that, I have made representation before the KMC. They did not taken any step. Writ petition is pending. They have not disclosed anything. So I will be praying for Lordship KMC be added as a party. Lordship, there is a direction of the Supreme Court, Lordship, that until and unless occupancy certificate is given, Lordship.
I will also pray, my instruction is such.
Okay, you do one thing. I am not adding as present. Let the CSC file the report.
Lordship.
Or the inspection can be carried out the CSC in presence of the municipal authority.
Lordship, as Lordship
inspected according to my instruction. They have made an application for new service connection on 20.
Correct. What has happened?
Subsequently, we have made an inspection and thereafter they have paid the amount. And there are subsequently we received objection letters.
Lordship, by my letter dated, I have objected.
You made a Kolkata Municipal Corporation as a party.
Lordship.
That notice be served. I am fixing next second week of the January. If the municipal authority will
grateful, Lordship.
The petitioner has filed the present application for grant of electric connection. The private respondent raised an objection and submitted that the petitioner has made the petitioner wherein the electric connection the petitioner has made construction in deviation of the building plan.
Lordship.
In deviation of the building plan. According the municipal corporation is the necessary party in the writ application and prays for direction upon the petitioner to implead the Calcutta Municipal Corporation as party respondent. The learned counsel for the petitioner handed over an order dated 4th June 2025 issued by the executive engineer within bracket C/building of the Kolkata of the Diamond Park of the Kolkata Municipal Corporation. Kolkata Municipal Corporation, wherein it reveals that the building plan and during the inspection it could not find any infringement of the KMC building rules 2009. Considering the above, the petition is directed to meet the Kolkata Municipal Corporation as party respondent within a week from date and to serve the notice to the Kolkata Municipal Corporation and to file the affidavit of service on the next date fixed. List the matter on 14th of January 2025 under the same heading.
I'm grateful, Lordship.
Next. Site.
Original site.
Where is the order?
Original site.
So these are all the 1 lakh plans.
82.
82 and other matters included. Actually, the, yeah.
82 to 98. 82 to 98. Learned counsel for the petition praised for extension of interim order. Who is for the authority? Nobody is there. Yeah. Though the matter is listed as item number 82 to 98, but due to paucity of time, the matter could not be taken up for hearing. Accordingly, the interim order is extended till 16th of January 2026 or until further order, whichever is earlier. Let the matter appear on 13th of January 2025. Affidavit of service filed by the petition be kept in the record. Under the same heading. Yes.
Lord, if my lord calls up original side matters, my lord, before my lord calls up original side matter, my lord wanted me to come back before rising.
Which matter?
That item 134 of the appellate side list. My lord.
What is the matter?
It's a tender matter. I'm not being able to my lord, put my bid 134. If my lord give some time tomorrow, my lord, 134.
134. Yes, who is for the other side?
Let's see, I'll notify them.
It may taken 134. It is in the urgent motion.
Leave matter, my lord.
34. Leave matter.
If the financial bid is opened, I don't know whether it is opened or not, then there will be nothing remains.
ठीक है, so कल ऊपर कर दो. 134 कल ऊपर कर दो.
Lord, I'm grateful.
Regarding 107, my lord, I heard this matter. This is that matter, my lord remembers where my client wanted to have a baby while the interview to go assist. Now, my lord, on that day, they said, my lord, the Union of India had preferred an appeal, but no trace of that. Now, my lord, problem is this is her last menstrual cycle. My lord, if your lordship, my lord, kindly do not take it up, my lord.
107. I think tomorrow it will come because tomorrow nothing, only the urgent. Let me see if I will reach. I will take the matter.
Well, if it is not reached, my lord, I may be permitted to mention. Great.
Item 31. Hello, I am present.
Huh?
Dialysis is present. 5 CWs I have to take.
31. So what do you want? What is your prayer?
There is this, my lord. I got license.
What license?
Also license. What happened, my lord?
What license?
Before expiry, I applied for legal on-shop license, liquor license.
Liquor license. And you are suffering from serious ill and liquor license. Sorry. Yes. You are selling the liquor and you are telling that you are suffering from the serious illness.
Advocate.
Very good case, sir. It is to be heard as an urgent motion. Tomorrow.
Ordinarily not, but since 31st is there, it is not.
Yes. Yes. Who is for the other side? Upadhyay. Yes. The counsel for the petition has mentioned the matter and prayed for extension of interim order. Counsel for the respondent defendant, plaintiff and plaintiff. Counsel for the defendant number 1 raised objection and submitted due to the order passed. Due to interim order, the respondent defendant number 1 is facing difficulties. Consider the submission made by the counsel for the parties. For the interest of justice, cases adjourned and the interim order is extended. I don't know when the time. कोई time है hearing के लिए? कब है date? तो पहले नहीं है 18th February at 3 p.m. 6th February 3 p.m. 6th February at 3 p.m. Entry mode is extended till 10th of February 2026 or until further order, whichever is received. Yes, next.
Item number 1 to be mentioned.
না দেখো কেন ওরা আমাদের দেয়নি এই কপি আমাদের দেয়নি
Record a note. Counsel for the defendant has filed written notes of argument. Have you served?
No,
they did not. So my advocate and record is taking
Let
revenge.
the same be kept with the record. CAV.
I'm deeply blessed.
Next.
Item number 2.
Yes.
I concluded my submission. It may come back to because your lordship takes my lord extensive note. My lord, the petitioner, my lord, wants to send his father and nephew to jail for allegedly violating an order, my lord, which I tried to demonstrate that there was no violation.
Yes, yes.
The document was executed prior to, my lord, the order was passed. That was the crux of it, my lord.
Yes. When you will come.
বলা হয়ে গেছে।
As per the prayer made by the counsel for the petitioner, let the matter appear on by date 10th February at 3 p.m. 10th February 3 p.m.
The interim order to continue to that day.
Interim order is extended till the next date of the
Only thing is, my lord, I know, difficult, but if prior date can be given.
That's my problem is that the appellate side.
Yes, a very heavy list, very
heavy list. Then
And
I
we
have to
every
add-
day see your lordship at least 40 mentionings happen in the morning. We see that. And your lordship is kind enough to at least, my lord, allow everybody to mention. That is
What can be done?